This is the brief on the Philippines' Comprehensive Dangerous Drugs Act of 2002. Republic Act No. 9165 is the country's unbelievably strict framework for combating illegal drugs, and it's essential for anyone studying the balance between state power and human rights. First, this law casts a massive net. It doesn't just punish users or sellers of drugs like marijuana or shabu, which is meth. It equally targets big fish like financiers and the absolute smallest fish like someone just visiting a drug den or holding paraphernalia. It's literally a giant dragnet. So you gotta ask, when a law criminalizes even the watchman at the door, where does the guilt actually stop? Second, because the scope is so vast and the penalties so harsh, the law demands incredibly strict police rules. Section 21 mandates a rigorous chain of custody, meaning cops must immediately inventory and photograph seized drugs right in front of witnesses, like media or politicians. It's basically an unbreakable receipt to prevent planting evidence, an act punished by death. But, do these rules actually stop corrupt cops in the real world? Finally, even with those strict procedures, the law overstepped, forcing the Supreme Court to step in. In landmark cases like Estepona v. Labrigo, they struck down a plea bargaining ban, and in Social Justice Society v. DDB, they ruled mandatory drug testing for politicians is unconstitutional because it violates privacy. It shows that no matter how serious the social ill of drugs is, the legislature can't just bulldoze over your constitutional rights. Ultimately, the fight against illegal drugs is a constant tug-of-war between harsh enforcement and fundamental constitutional rights.
Under the original provisions of the Revised Penal Code, Philippine drug law was highly localized. Articles 190 through 194 focused on the immediate physical act, prosecuting the individual buyers and sellers caught in possession, preparation, or use of prohibited drugs. These statutes left high-level architects untouched. While a street dealer could be arrested for an opium pipe or a small sale, the financiers and managers remained insulated by front companies, mail fraud, and chemical diversion, actions the old laws were not designed to track. Republic Act No. 9165, the Comprehensive Dangerous Drugs Act of 2002, replaced these fragmented laws with a synchronized supply chain attack. The law now targets the entire logistical ecosystem. It penalizes the offshore financing, the clandestine manufacturing, the chemical diversion, and the local political protection shielding the operation. RA 9165 serves as the statutory net cast over this entire network. Securing a conviction requires the prosecution to satisfy the precise statutory elements assigned to each specialized role. If the state fails to meet even one requirement for a specific node, the case against that individual collapses. Before analyzing a single criminal act, the law requires a strict legal categorization of the physical substance involved. This image of morphine sulfate illustrates what the law classifies as a dangerous drug. These are the final, strictly regulated narcotic products, substances like shabu, marijuana, or ecstasy, listed under the UN conventions. In contrast, controlled precursors and essential chemicals are the raw materials and solvents. These chemicals have widespread legitimate industrial uses, but they are heavily monitored because they are required to synthesize the final narcotic. Legally separating the final drug from its precursors allows the state to indict upstream suppliers and chemical smugglers who facilitate the trade, even if they never physically touch a single grain of the final narcotic. To map how the state dismantles syndicates, we build an element matrix. The first column covers Node 1, importation, under Section 4. To prove this, the state verifies two elements. The offender brought dangerous drugs or precursors into the Philippines without legal authority. Jurisprudence is rigid. Under the doctrine of U.S. v. Luk Chow, prosecutors must prove the vessel actually came from a foreign port. A foreign merchant vessel merely anchored in transit through Philippine waters does not trigger criminal liability. Section 4 extends life imprisonment beyond the physical smuggler. It explicitly targets the executives, the organizers, managers, financiers, and the protectors who shield them. Once the materials are in the country, the matrix shifts to Node 2, manufacture, under Section 8. Manufacture covers the production, compounding, or processing of dangerous drugs. However, the statute explicitly exempts preparation by duly authorized practitioners for medical practice, research, or chemical analysis. When illicit production occurs, it usually happens in a clandestine laboratory. Section 8 outlines specific aggravating circumstances that maximize the penalty: conducting the process near a school, securing the lab with booby traps, or concealing it within legitimate businesses. By strictly defining manufacture and its aggravators, the state acquires the legal authority to seize property and penalize the corporate fronts leasing the infrastructure, rather than settling for the arrest of low-level chemists. Prior to RA 9165, law enforcement had a massive blind spot. Legitimate corporations would import essential chemicals, then quietly slip them into the black market. The statutory solution is chemical diversion, mapped in Section 9 of the Matrix. First, the offender must have legal authorization to possess the controlled precursors. Second, they commit an unauthorized diversion of those chemicals. This provision specifically targets white-collar criminals who use corporate licenses to traffic raw materials under the guise of legitimate commerce. By criminalizing the diversion itself, prosecutors possess the legal bridge required to pierce the corporate veil and sever the syndicate supply lines before the drugs are ever manufactured. From the boardroom, the product filters down to the street. This is the distribution network, governed by Section 5. Section 5 covers a massive scope of activity. It penalizes trading, administration, dispensation, delivery, and transportation of dangerous drugs or their precursors. The Matrix breaks down the most commonly litigated offense: sale. Following People v. Esguerra, prosecutors must prove three things: identity of the parties, the object and consideration, and the delivery and payment. That exact moment of transfer is where criminal liability attaches. To capture these exact elements occurring simultaneously, the state relies on the buy-bust operation, a form of entrapment designed to catch the peddler in flagrante delicto. Courts grant significant operational leeway during these operations. As noted in People v. Trunca, a formal mission order or prior surveillance are not strictly required for a valid entrapment. Section 5 distills the chaos of an undercutter operation down to a rigid three-element checklist. If the prosecution fails to prove even one element beyond a reasonable doubt, the case collapses. Consumption happens in physical spaces. Sections 6 and 7 govern the maintenance of drug dens. The law applies a tiered liability structure here. Maintainers and owners face the heaviest penalties, while employees and visitors are prosecuted under Section 7. Prosecuting a visitor carries a specific evidentiary hurdle based on the U.S. v. Saibun-Ku doctrine, explicit proof of knowledge. Mere physical presence is legally insufficient unless the state proves the visitor knew the venue was an operating drug den. When the state cannot prove a sale or a den's maintenance, it relies on Section 11, illegal possession, the most litigated section of RA 9165. The severity of the penalty for possession is scaled entirely by quantitative thresholds. The law ignores drug purity and focuses exclusively on the gross weight of the seized substance. This chart compares life imprisonment thresholds, 50 grams for shabu versus a massive 500 grams for marijuana. Weight dictates penalty, but conviction relies on one overarching requirement: animus possidendi, the intent to possess. Actual physical custody proves intent, but under U.S. v. Changai 1, constructive possession, retaining control and management without physically touching the drugs, carries the exact same legal weight. Possession serves as the legal catch-all for prosecutors when complex distribution networks cannot be proven, relying entirely on raw weight and proven intent. RA 9165 imposes life imprisonment and massive financial penalties. Because the stakes are absolute, the judiciary enforces incredibly strict evidentiary safeguards to prevent state abuse. The primary defense against extortion or harassment is Section 29, defining the statutory crime of planting of evidence. Under the old RA 7659, the offender for planting evidence had to be a government official. RA 9165 expanded liability, so the offender can be any person. This protects citizens from both corrupt police and malicious individuals surreptitiously planting drugs. Generally, Section 98 of RA 9165 dictates that drug crimes are malum prohibitum. The act is wrong simply because the law forbids it, which typically renders the provisions of the Revised Penal Code inapplicable. However, the Supreme Court established a critical exception in People v. Simon. They ruled that favorable provisions of the Revised Penal Code, such as Article 22, which allows the retroactive application of lighter penal laws, can still be applied to RA 9165 cases. In high-stakes drug litigation, the Supreme Court sets a standard. The presumption of innocence always prevails over the presumption of regularity if the prosecution fails to satisfy the strict requirements of the element matrix. Re-establishing the network highlights how RA 9165 aims to dismantle the infrastructure of the drug trade. Success in these cases centers on the proof of the specific elements attached to a single action in the supply chain. Mastery of Philippine criminal law requires stripping away the generalized narratives of the drug war. Success belongs to those who rigorously master the element matrix.
Articles 190 to 193 of the Revised Penal Code concerning dangerous drugs were repealed by Republic Act No. 6425, or the Dangerous Drugs Act of 1972. This act, in turn, was superseded by Republic Act No. 9165, or the Comprehensive Dangerous Drugs Act of 2002. The Dangerous Drugs Act of 1972, or RA 6425, as amended, punished several acts related to prohibited drugs. These included importation, sale, maintenance of a den, being an employee or visitor of a den, manufacture and possession or use of prohibited drugs. All of these provisions have been repealed. Other repealed acts under RA 6425 included cultivation of plants that are sources of prohibited drugs, failure to comply with record-keeping provisions, unlawful and unnecessary prescription, possession of paraphernalia, and various acts related to regulated drugs. We now examine the Comprehensive Dangerous Drugs Act of 2002, Republic Act No. 9165. Historically, amendments to the Dangerous Drugs Act of 1972 were retroactively applied, as seen in cases like People v. Simon. Favorable provisions of the 2002 Act may also be applied retroactively. Pertinent provisions of the Revised Penal Code were previously considered suppletory to the Dangerous Drugs Act of 1972. Under the Comprehensive Dangerous Drugs Act of 2002, however, Revised Penal Code provisions are inapplicable, except for minor offenders. Violations of the 1972 Act were not considered felonies, although this rule has changed. The declared policy of the Comprehensive Dangerous Drugs Act of 2002 is to enhance the law's efficacy against dangerous drugs, recognizing them as a serious social ill. This includes pursuing an intensive campaign against trafficking and use of dangerous drugs through an integrated system of planning and enforcement. Other declared policies include achieving a balance in the National Drug Control Program, ensuring people with legitimate medical needs can access appropriate medication. It also involves providing effective mechanisms to reintegrate victims of drug abuse or dependence into society through treatment and rehabilitation programs. Article 1 of RA 9165 defines key terms. Administer means introducing dangerous drugs into a person's body, with or without their knowledge, by injection, ingestion, or other means. It also includes indispensable assistance to someone administering a dangerous drug to themselves. The board refers to the Dangerous Drugs Board created under the Act. Centers refer to the treatment and rehabilitation centers mentioned in the Act. Chemical diversion is a new definition under RA 9165. It means the sale, distribution, supply, or transport of legitimately procured controlled precursors and essential chemicals to any entity engaged in the manufacture of any dangerous drug. This includes fraudulent packaging, relabeling, or concealment. Clandestine laboratory is defined as a facility used for the illegal manufacture of any dangerous drug, controlled precursor, or essential chemical. A confirmatory test is an analytical test using a different principle to validate and confirm the result of a screening test. Controlled delivery is an investigative technique allowing a suspicious consignment of dangerous drugs or related items to pass through the country under supervision. The purpose is to gather evidence to identify persons involved in drug offenses or to facilitate prosecution. Controlled precursors and essential chemicals are listed in international conventions and annexed to the Act. Cultivate or culture is defined as knowingly planting, growing, or raising a plant which is the source of a dangerous drug, or knowingly permitting such activities. The definition of dangerous drugs under RA 9165 completely overhauls the previous definition, which distinguished between prohibited and regulated drugs. They now include substances listed in the schedules annexed to the 1961 and 1971 single conventions. Deliver means knowingly passing dangerous drugs to another, personally or otherwise, with or without consideration. A den, dive, or resort is a place where any dangerous drug or controlled precursor and essential chemical is administered, delivered, stored, distributed, sold, or used for illegal purposes. The term dispense is defined as any act of giving away, selling, or distributing medicine or any dangerous drug with or without the use of a prescription. Drug dependence is redefined based on the World Health Organization's definition. It involves a cluster of physiological, behavioral, and cognitive phenomena where psychoactive drug use takes on a high priority. This includes a strong desire or compulsion to take the substance and difficulties controlling its use. A drug syndicate is an organized group of two or more persons forming or joining together with the intent to commit any offense under the Comprehensive Dangerous Drugs Act of 2002. An unquote employee of drug den, dive, or resort refers to persons employed by the maintainer, owner, or operator where drugs or essential chemicals are illegally handled. Employees of a drug den, dive, or resort include caretakers, helpers, watchmen, lookouts, and other persons working in such a place, with or without compensation. A financier is any person who pays for, raises, supplies money for, or underwrites any of the illegal activities under the Act. Illegal trafficking includes illegal cultivation, culture, delivery, administration, dispensation, manufacture, sale, trading, transportation, distribution, importation, exportation, and possession of dangerous drugs or controlled precursors. An instrument is anything used or intended to be used in any manner in the commission of illegal drug trafficking or related offenses. Laboratory equipment refers to paraphernalia, apparatus, materials, or appliances used or designed for use in the manufacture of dangerous drugs or controlled precursors and essential chemicals. Manufacture is the production, compounding, or processing of a dangerous drug, directly or indirectly, or by chemical synthesis. It also includes packaging or labeling of such substances. Exceptions to manufacture include preparation or compounding by an authorized practitioner incidental to their professional practice, and activities like research, teaching, and chemical analysis not intended for sale. Cannabis or marijuana refers to the plant Cannabis sativa in all its forms and parts. This includes hashish, bhang, guaza, churras, and ganjab. The definition of cannabis also includes the dried, fresh, flowering, or fruiting tops of the plant, its parts, portions, seeds, and all geographic varieties in any form, such as reefer, resin, extract, and tincture. Methylenedioxymethamphetamine or ecstasy and methamphetamine hydrochloride or shabu are defined as drugs having such chemical compositions, including any of their isomers or derivatives in any form. Opium is the coagulated juice of the opium poppy and includes all its forms, narcotic preparations, morphine, and other alkaloids of opium, and preparations containing them as an ingredient. The term opium also includes opium poppy, opium seeds, opium poppy straw, and leaves or wrappings of opium leaves. Opium poppy is defined as any part of the plant species Papaver somniferum, including its seeds. PDEA refers to the Philippine Drug Enforcement Agency. Person is defined as any entity, natural or juridical, including a corporation, partnership, trust, estate, joint stock company, association, syndicate, joint venture, or other unincorporated organization. Planting of evidence is the willful act of maliciously and surreptitiously placing any quantity of dangerous drug or controlled precursor in the person, house, effects, or immediate vicinity of an innocent individual to implicate them in a violation of the act. The definitions continue with a look at planting evidence under Section 3 and Section 29 of Republic Act No. 9165. This should be compared with the previous provisions under Republic Act No. 6425 as amended. The elements of planting evidence under RA 9165 involve any person committing a willful act of maliciously and surreptitiously planting dangerous drugs or controlled chemicals. This act can involve inserting, placing, adding, or attaching overtly or covertly, directly or indirectly, whatever the quantity. The planting of dangerous drugs must be in the person, house, effects, or immediate vicinity of an innocent individual. The offender's purpose must be to incriminate the individual for a violation of the Comprehensive Dangerous Drugs Act of 2002. Under the old provisions, the offender was contemplated as a government official, employee, or member of police or armed forces. The current provisions expanded the offender to include any person. Planting evidence for extortion or to harass a witness is condemned. While regularity is presumed in official acts, the presumption of innocence prevails. The defense of, quote, frame-up is sometimes viewed as a standard defense in drug cases. A practitioner is a licensed physician, dentist, chemist, medical technologist, nurse, midwife, veterinarian, or pharmacist in the Philippines. A protector/coddler is a person who knowingly and willfully consents to unlawful acts under the Act and uses their influence to shield or facilitate the escape of a violator. The elements of protector/coddler are: the offender is a person of influence, power, or position. They knowingly consent to unlawful acts, use their influence to shield, harbor, screen, or facilitate escape, and know or suspect the person is a violator, with the intent to prevent arrest and conviction. Pusher refers to a person selling, administering, delivering, or giving away dangerous drugs, or acting as a broker. School is broadly defined as an educational institution, public or private, operating at defined levels. A screening test is a rapid test performed to establish a potential or presumptive positive result. To sell is the act of giving dangerous drugs or controlled chemicals for money or other consideration. Possession is distinct from sale unless the amount possessed is intended for sale. Trading refers to illegal trafficking transactions of dangerous drugs or chemicals using electronic devices. This includes text messages, email, mobile or landlines, and two-way radios. Trading also involves illegal transactions using the internet, instant messengers, chat rooms, or acting as a broker in any of these transactions for any consideration, in violation of the Act. To use means injecting, consuming, chewing, smoking, sniffing, eating, swallowing, drinking, or otherwise introducing any dangerous drug into the body's physiological system. The term narcotic drug was eliminated from the current Act, although the substances it covered are still defined in Section 3, including opium, opium derivatives, and synthetic opiates. The term score, in drug trade common parlance, means to buy. A buy-bust operation is a form of entrapment used to apprehend a pusher or peddler in flagrante delicto. This practice, however, has been noted as susceptible to abuse. It is important to note that a formal complaint, mission order, or prior surveillance is not required before a buy-bust operation is conducted. The law does not mandate a specific standard procedure for this operation. We continue to cover the importation of dangerous drugs, controlled precursors, or essential chemicals under the Comprehensive Dangerous Drugs Act of 2002. Penalties include life imprisonment to death and fines for importing dangerous drugs, or 12 to 20 years and fines for importing controlled precursors. Acts punished under Section 4 include illegal importation of dangerous drugs or controlled precursors, acting as an organizer or financier in such importation, and acting as a protector or coddler. The elements of importation of dangerous drugs require the offender to import or bring the drug into the Philippines. Case law defines what constitutes importation, including possession on a foreign vessel after arriving directly from a foreign port, unless the vessel is merely in transit. Importation is a separate crime from possession, so acquittal for importation does not bar a conviction for possession. Dangerous drugs include opium poppy and substances derived from it, even those for floral or culinary use. Quantity and purity of the drug are immaterial. The elements of importation of dangerous drugs include the offender importing the drug into the Philippines, the drug being prohibited, and the offender not being authorized by law to do so. The elements for the importation of controlled precursors or essential chemicals require the offender to import a substance into the Philippines, the substance being a controlled precursor or essential chemical of dangerous drugs, and the offender lacking legal authorization. For the crime of acting as an organizer, manager, or financier in importation, the elements are that dangerous drugs or controlled precursors were imported illegally into the Philippines, and the offender acted in one of these roles in the importation. The elements for acting as a protector or coddler involve a person illegally importing drugs or acting as an organizer, manager, or financier in the illegal importation, and the offender acting as a protector or coddler of this person or persons. This section covers penalties for sale, trading, administration, dispensation, delivery, distribution, and transportation of dangerous drugs and/or controlled precursors. The penalty applies to participants and brokers involved in simple trading or distribution of both drugs and precursors. Penalties also apply to organizers, managers, or financiers involved in these illicit activities with dangerous drugs or controlled precursors. Furthermore, they apply to those acting as protectors or coddlers of participants and brokers. These acts are considered specially aggravated, potentially incurring the maximum penalty if they occur within 100 meters of a school, involve minors or mentally incapacitated individuals as runners, or if the prohibited drug causes the victim's death. Being an organizer also aggravates the crime. We compare the current penalties with those under old provisions. Old provisions included simple and specially aggravated categories, such as when the victim is a minor, or the prohibited drug is the proximate cause of death. Special aggravating circumstances could also be applied. Persons liable include those engaging in the sale, trading, administration, dispensation, delivery, distribution, and transportation of dangerous drugs and/or controlled precursors. Liability also extends to brokers, organizers, managers, financiers, protectors, and coddlers of these activities. The acts punished include the sale, trading, administration, dispensation, delivery, distribution, and transportation of dangerous drugs. An essential element is that the offender is not authorized by law to conduct these activities. Proof of ownership is immaterial for unlawful transportation charges. The offender must sell, trade, administer, deliver, give away to another, distribute, dispatch in transit, or transport dangerous drugs. The elements of a sale include the identity of the buyer and seller, the object, consideration, and the delivery of the item sold with payment transfer. This scene discusses those acting as brokers in the sale, trading, administration, delivery, giving away to another, distribution, dispatching in transit, or transportation of dangerous drugs, requiring that the offender did not perform the main activities but acted as a broker. The focus now shifts to the sale and related activities involving controlled precursors or essential chemicals. The elements include the offender not being authorized to engage in these activities and actually selling, trading, or transporting the controlled precursor or essential chemical. The elements for acting as a broker concerning controlled precursors or essential chemicals require that the offender did not perform the main activities themselves, but acted as a broker in the sale, trading, or transportation of the substance. This scene details the elements for organizing, managing, or financing the illicit activities of dangerous drugs or controlled precursors. The offender must not be authorized to conduct these activities and must be involved in organizing, managing, or financing the defined activities. The crime of acting as a protector or coddler of persons engaged in these activities has specific elements. The offender must not be involved in the principal acts, but must act as a protector or coddler of those who are involved. Moving to Section 6, we discuss the maintenance of a den, dive, or resort. Penalties apply to the maintainer, owner, operator, organizer, manager, financier, or protector/coddler of a place where dangerous drugs or controlled precursors are sold or used. There are specially aggravated circumstances for this crime. These include administering or selling a prohibited drug to a minor in the place, the drug causing the death of a person using it there, or being the organizer, manager, or financier of the den. The individuals liable for maintaining a den, dive, or resort may be a person or group of persons. The essential elements for dangerous drugs are maintaining a den and dangerous drugs being used in any form in that place. The elements for maintaining a den for controlled precursors or essential chemicals require the offender to be a person or group maintaining the place and the substance being used in any form in that den, dive, or resort. For organizing, managing, or financing the maintenance of a den, the offender must act in one of these roles, and dangerous drugs or precursors must be used in any form in the establishment. If an offender acts as a protector or coddler for a drug den, they must not be the organizer, manager, financier, maintainer, owner, or operator. They must merely act as a protector, and dangerous drugs or precursors must be used in the den. Section 7 addresses employees and visitors of a den, dive, or resort. Penalties are imposed on employees and visitors of a prohibited drug den. Individuals liable include employees and visitors of a prohibited drug den, dive, or resort. Two acts are punished under the previous legislation, employment at a prohibited drug den. The elements require the offender to be an employee, and dangerous drugs or controlled precursors to be used in any form in the location. The second act punished is knowingly visiting a prohibited den. Elements include the offender not being an employee, visiting the den, and knowing that dangerous drugs or controlled precursors are used there. A key rule for confiscation of a den owned by a third person is that the criminal complaint must specifically allege the place was intentionally used to further the crime. The prosecution must prove the owner's intent, and the owner must be included as an accused. This section covers the manufacture of dangerous drugs and/or controlled precursors, including penalties for the simple act, and for acting as a protector or coddler of those involved in the manufacture. Aggravated circumstances apply to clandestine laboratories, such as conducting manufacturing in the presence of minors, establishing the lab within 100 meters of certain premises, securing it with booby traps, or concealing it within legitimate business operations. The maximum penalty is imposed for specially aggravated offenses, such as acting as an organizer, manager, or financier of the manufacturing activities. The elements of manufacture of dangerous drugs are engaging in the manufacture and lacking legal authorization. The elements for the manufacture of a controlled precursor or essential chemical require the offender to engage in the manufacture of such a substance of dangerous drugs, without being authorized by law to do so. For acting as an organizer, manager, or financier, the elements include the offender not being directly engaged in manufacture, but organizing, managing, or financing the illegal manufacturing activities of others. The elements for acting as a protector or coddler involve the offender not being involved in the manufacturing or organization, but acting to protect or coddle those who are engaged in these illegal activities. Next, we discuss illegal chemical diversion of controlled precursors and essential chemicals, which is a new offense under the Comprehensive Dangerous Drugs Act. The penalty is specified in Section 9. Acts punished include illegally diverting controlled precursors, even if initially authorized to possess or use them. This section introduces the manufacture or delivery of equipment, instruments, apparatus, and other paraphernalia for dangerous drugs or controlled precursors. Penalties are detailed in Section 10. The acts punished include the delivery, possession with intent to deliver, or manufacture with intent to deliver paraphernalia used in planting, cultivating, manufacturing, processing, or concealing dangerous drugs or controlled precursors, with the knowledge or reasonable presumption of its illegal use. The elements cover delivery, possession with intent to deliver, or manufacture with intent to deliver paraphernalia for dangerous drugs, with the knowledge that it will be used to introduce a dangerous drug into the human body illegally. A special aggravating circumstance, resulting in the maximum penalty, is the use of minors or mentally incapacitated individuals to deliver such drug paraphernalia. We now examine the possession of dangerous drugs under Section 11. Historically, possession requires a demonstration of occupancy or taking, and mere possession without knowledge that the item is a prohibited substance may be insufficient for conviction. The penalty for possession is discussed, noting that possession requires intent and must not be authorized. Case law states that it is not necessary to allege a lack of authorization in the information, as this is a defense element. The law punishes present, not past, possession. Possession is not limited to manual touch, encompassing constructive possession where an owner exercises control, management, and disposition of the substance. The elements of possession of 10 grams or more of opium require the offender to possess opium, lack legal authorization, and the quantity be 10 grams or more, regardless of its purity. This video examines the possession of dangerous drugs, specifically focusing on Section 11 of Republic Act No. 9165. We start with the elements of possessing 10 grams or more of morphine under the Comprehensive Dangerous Drugs Act of 2002. Next, we look at the elements for possessing 10 grams or more of heroin. The Act requires that the offender possesses heroin, is not authorized by law to do so, and the quantity is 10 grams or more, regardless of purity. Similarly, the elements for possessing 10 grams or more of cocaine or cocaine hydrochloride require the offender to possess the substance without legal authorization, with the quantity being 10 grams or more. For methamphetamine hydrochloride or shabu, the threshold is higher. The elements specify possessing 50 grams or more of this substance without authorization, regardless of its purity. Moving to cannabis derivatives, the elements for possessing 10 grams or more of marijuana resin or marijuana resin oil are examined. These include unauthorized possession of the substance, where the quantity is 10 grams or more. The Comprehensive Dangerous Drugs Act sets the quantity element for possession of marijuana at 500 grams or more. The offender must possess marijuana, not be authorized to do so, and the quantity must meet or exceed 500 grams. Possession of 10 grams or more of other dangerous drugs is also covered. This includes a list of various substances like MDMA or ecstasy, PMA, TMA, LSD, and GHB. This also applies to similarly designed or newly introduced drugs without therapeutic value, or those possessed far beyond therapeutic requirements. The elements require possession without authorization, and the quantity must be 10 grams or more. Next, we review the possession of 10 grams or more but less than 50 grams of methamphetamine hydrochloride or shabu. The elements require unauthorized possession of this specified quantity. For opium, the possession of 5 grams or more but less than 10 grams constitutes the offense. As with other drugs, unauthorized possession of the specified quantity is required. The elements for the possession of 5 grams or more but less than 10 grams of morphine are the same. This unauthorized possession requires the quantity to be within the specified range. Similarly, possessing 5 grams or more but less than 10 grams of heroin involves the same elements, unauthorized possession of the specific quantity of the substance. The rule applies to cocaine and cocaine hydrochloride as well. Unauthorized possession of 5 grams or more but less than 10 grams of either substance fulfills the quantity element. For marijuana resin or marijuana resin oil, possessing 5 grams or more but less than 10 grams illegally is covered here. The elements remain constant regarding unauthorized possession and quantity. Finally, for marijuana, unauthorized possession of 300 grams or more but less than 500 grams is defined as a violation. The quantity, regardless of purity, must fall within this range. We now examine the possession of 5 grams or more, but less than 10 grams of other dangerous drugs. The elements require unauthorized possession of the listed drugs, or similar unclassified drugs, where the quantity is within this range. These other dangerous drugs include substances like GHB and other unclassified drugs, as determined by the Dangerous Drugs Board, that lack therapeutic value or are possessed beyond therapeutic requirements. Next is the possession of less than 5 grams of methamphetamine hydrochloride, or shabu, though the note indicates it should read less than 10 grams. The elements are unauthorized possession, and the quantity is less than 10 grams. For opium, the offense is possession of less than 5 grams. The offender must possess opium, not be authorized by law, and the quantity is less than 5 grams, regardless of purity. Possession of less than 5 grams of morphine is also a violation. The required elements are unauthorized possession of morphine, with a quantity of less than 5 grams. The same threshold applies to heroin, unauthorized possession of less than 5 grams. The quantity is less than 5 grams, regardless of its purity. For cocaine or cocaine hydrochloride, possession of less than 5 grams is the offense. The elements require unauthorized possession where the quantity is less than 5 grams. If the substance is marijuana resin or marijuana resin oil, the offense is unauthorized possession of less than 5 grams. The quantity is key, regardless of purity. Possession of less than 300 grams of marijuana is also covered under this section. The elements specify unauthorized possession of marijuana with a quantity of less than 300 grams. The elements for possession of less than 5 grams of other dangerous drugs are similar. This includes unauthorized possession of any other listed drug or similarly designated drug, where the quantity is less than 5 grams. These other dangerous drugs include those listed previously, such as GHB, and substances without therapeutic value, or those possessed in excessive therapeutic quantities. The quantity must be less than 5 grams. We move on to Section 12, regarding the possession of equipment for dangerous drugs. The penalty and elements are defined here, with a comparison to the older law. One element is the unauthorized possession of paraphernalia fit or intended for using any dangerous drug. The Dangerous Drugs Board may prescribe guidelines for medical and other professionals. Possession of these prohibited items is considered prima facie evidence that the possessor has used a dangerous drug. This is presumed to be a violation of Section 15 of the Act. Finally, we discuss the special aggravating circumstances for possessing dangerous drugs during parties, social gatherings, or meetings. This applies to possession in the proximate company of at least 2 persons. We now examine Section 14 of Republic Act No. 9165, concerning the possession of equipment and paraphernalia for dangerous drugs during parties, social gatherings, or meetings. This is an aggravating circumstance not found in the previous law. The special aggravating circumstances include possessing paraphernalia intended for consuming dangerous drugs at a party, social gathering, or meeting. This also applies when in the proximate company of at least 2 other persons. Next, we address the use of dangerous drugs under Section 15 of RA No. 9165. For a first offense, the penalty involves a minimum of 6 months rehabilitation in a government center. The elements of a first offense include an arrest for apparent positive drug use, confirmation by test, the finding of positive use, and no previous apprehension or conviction for drug use rehabilitation. For a second offense of dangerous drug use, the penalty increases significantly to 6 years and 1 day to 12 years imprisonment, plus a fine ranging from P50,000 to P200,000. Only the penalty for the first offense in connection with drug use is subject to the treatment and rehabilitation program under Article 8 of the Act. We shift our focus to Section 16, which penalizes the cultivation or culture of plants classified as dangerous drugs. Penalties include life imprisonment to death and a fine of P500,000 to P10 million. Aggravated circumstances for cultivation include involving land part of the public domain or acting as an organizer, manager, financier, protector, or coddler of such prohibited activities. The law clarifies that a landowner is not subject to penalty merely for being the owner, even if they knowingly allow cultivation. The offender must be the one who plants, cultivates, or cultures the dangerous drugs. However, the land is subject to confiscation if the owner fails to prove absence of knowledge of the illegal cultivation. Exceptions exist for medical experiments under strict Dangerous Drugs Board guidelines. Section 17 covers the maintenance and keeping of original records for dangerous drug transactions. The basic penalty is 1 year and 1 day to 6 years imprisonment, plus a fine of P1,000 to P6,000. The offense primarily relates to the failure to comply with the record-keeping requirements outlined in Section 40 of RA No. 9165, particularly regarding controlled precursors and essential chemicals. Persons liable include a broader list of practitioners under the new law, such as licensed physicians, dentists, chemists, medical technologists, nurses, midwives, veterinarians, and pharmacists. Other liable persons include manufacturers, wholesalers, distributors, dealers, and retailers involved in transactions of dangerous drugs and/or controlled precursors and essential chemicals. Finally, we discuss the penalty for unnecessary prescription of dangerous drugs under Section 18. This offense carries a basic penalty of 12 years and 1 day to 20 years, and a fine of P100,000 to P500,000, along with license revocation. We continue to cover the unnecessary prescription of dangerous drugs, comparing Republic Act No. 9165 with Section 12 of Republic Act No. 6425 as amended. Republic Act No. 9165 is known as the Comprehensive Dangerous Drugs Act of 2002. It includes Article 2 on unlawful acts and penalties. The Act lists various practitioners, including licensed physicians, dentists, chemists, medical technologists, nurses, midwives, veterinarians, and pharmacists, as practitioners under the law. The elements of unnecessary prescription include the offender being a practitioner, the offender prescribing a prohibited drug for any person, and the physical or physiological condition of that person not requiring the use or the prescribed dosage of the prohibited drug. This section covers the unlawful prescription of dangerous drugs under Section 19 of Republic Act No. 9165, comparing it with Sections 11 and 18 of Republic Act No. 6425. The penalty is life imprisonment to death and a fine of P500,000 to P10 million. The elements of this offense are that the offender makes or issues a prescription or writing purporting to be a prescription for a dangerous drug, and the offender is not authorized by law to make or issue such a prescription. We now discuss the confiscation and forfeiture of proceeds or instruments from unlawful acts, including properties derived from the illegal trafficking of dangerous drugs and essential chemicals. This is under Section 20 of Republic Act No. 9165. Items subject to confiscation relate to dangerous drugs, controlled precursors, and essential chemicals, which include unlawful importation, sale, trading, administration, dispensation, distribution, transportation, and manufacture. Other items subject to confiscation include the possession of prohibited devices relative to dangerous drugs, such as equipment, instruments, apparatus, other paraphernalia, and other laboratory equipment. Also included is the cultivation of plants, which are sources of dangerous drugs. Items subject to confiscation include proceeds and other properties derived from an unlawful act and instruments or tools used to commit the unlawful act. However, property belonging to third persons not liable for the offense is not subject to confiscation. The disposition of confiscated items not of lawful commerce must be destroyed without delay, as per the provisions of Section 21 of Republic Act No. 9165. The procedure for confiscation after conviction involves a hearing for confiscation and forfeiture of all proceeds and assets found to be manifestly disproportionate to the accused's lawful income. For sale and disposition of confiscated property, a confiscated vehicle should be auctioned off not later than 5 days upon the order of confiscation or forfeiture. Proceeds from the sale cover expenses, with the excess accruing to the board for its campaign against illegal drugs. During the pendency of the case, no property or income subject to confiscation shall be disposed of, alienated, or transferred, and no bond shall be admitted for its release. The PDEA is responsible for the custody and proper disposition of confiscated, seized, and/or surrendered dangerous drugs, plant sources, controlled precursors, essential chemicals, instruments, paraphernalia, and laboratory equipment. This includes all dangerous drugs, plant sources, and controlled precursors and essential chemicals, as well as instruments, paraphernalia, and laboratory equipment so confiscated, seized, and/or surrendered. The procedure for turnover of custody to PDEA, filing a case in court, and final disposition involves a physical inventory and photographing upon apprehending team acquiring initial custody. This must be done in the presence of the accused or their representative, a representative from the media, the Department of Justice, and any elected public official. Physical inventory and photographs should be taken at the place where the search warrant is served, or the nearest police station/office in the case of warrantless seizures. Non-compliance is excused if the integrity and evidentiary value of the seized items are preserved. A certification of forensic laboratory examination results should be issued immediately upon receipt of the items, with provisions for a provisional report if testing completion is delayed. Upon filing a criminal case, an ocular inspection of confiscated items should be conducted by the court within 72 hours. This inspection covers dangerous drugs, plant sources, controlled precursors, essential chemicals, instruments, paraphernalia, and laboratory equipment. Destruction or burning of subject items must be done by the PDEA within 24 hours after ocular inspection. This is done in the presence of the accused or their representative, media, the DOJ, civil society groups, and an elected public official. The cost and manner of destruction are borne by the offender, following guidelines set by the board. Items of lawful commerce, as determined by the board, can be donated, used, or recycled. A representative sample is retained. The alleged offender or their representative can observe the destruction proceedings, which does not constitute an admission of guilt. If the accused fails to appoint a representative, the Secretary of Justice appoints a public attorney. A sworn certification must be submitted regarding the destruction of items and representative samples to the court. These representative samples are kept at a minimum quantity determined by the board. The final disposition follows the conclusion of the trial, promulgation, and judgment of the criminal case. Upon final termination of the case, the trial prosecutor informs the board. They request the court's permission to turn over representative samples to the PDEA for proper disposition and destruction within 24 hours of receipt. The prosecutor then turns over the samples to the PDEA for disposition and destruction. A sworn certification is required regarding the destruction or burning of the items, conducted within 72 hours by the court where the criminal case is pending. The transitory provisions of Sec 21 of Representative Act No. 9165 cover burning and destruction within 24 hours from the act's effectivity for dangerous drugs in law enforcement possession, with the DOH undertaking this before the PDEA's organization. Chemical analysis is not an indispensable requisite to establish whether a substance is prohibited or not. However, failure to prove that the specimen examined by the forensic chemist was the one sold by the accused is damaging to the prosecution, based on the chain of custody theory. The drug itself is the very corpus delicti, and its existence is a condition sine qua non for conviction. We now cover the grant of compensation, reward, and award under Sec. 22 of Republic Act No. 9165. The requisites included the grantee being a person providing information or a law enforcement officer participating in the operation. The offense must involve seized or confiscated dangerous drugs, plant sources, proceeds, or instruments of crimes, resulting in successful confiscation. The award is granted by the concerned government agency upon the board's recommendation. The plea bargaining provision, Sec. 23 of Representative Act No. 9165, initially disqualified persons charged with the Comprehensive Dangerous Drugs Act from availing of plea bargaining, regardless of the penalty. However, in Estepona v. Labrigo, the Supreme Court declared the statutory prohibition against plea bargaining in drug-related cases unconstitutional. The Supreme Court clarified that plea bargaining is a rule of procedure under the judiciary's exclusive rulemaking authority. The prohibition in Republic Act No. 9165 violated the separation of powers. This landmark decision aims to protect the institutional independence of the courts and ensure the speedy disposition of criminal cases. The non-applicability of the probation law for drug traffickers and pushers is covered in Sec. 24 of Republic Act No. 9165. Persons convicted for drug trafficking and pushing are disqualified from probation benefits, regardless of the penalty. This refers to the privilege of probation under Presidential Decree No. 968, as amended. The elements of disqualification from probation include the offender being convicted of violating the Comprehensive Dangerous Drugs Act and the conviction being for drug trafficking or pushing. Drug trafficking encompasses various illegal acts, including cultivation, manufacture, sale, and possession of dangerous drugs and precursors. Drug pushing is defined as selling, trading, or distributing dangerous drugs. Section 25 addresses qualifying aggravating circumstances when a crime is committed by an offender under the influence of dangerous drugs. This carries over provisions from BPBLG 179 with a modification. It provides for the appreciation as a qualifying circumstance if there is a positive finding for the use of dangerous drugs during the crime's commission. The elements for appreciation as a qualifying circumstance are that the offender has committed a crime and a positive finding exists that the offender used dangerous drugs during the crime's commission. There is ambiguity in the consequence of a positive finding regarding the application of the Revised Penal Code penalty. Sec. 26 covers attempt or conspiracy, penalized the same as consummated crimes for specific offenses. These include importation of dangerous drugs or controlled precursors and essential chemicals. They also cover the sale, trading, administration, dispensation, delivery, distribution, and transportation of these items. Conspiracy or attempt is also penalized the same as consummated crimes for the maintenance of a den, dive, or resort where any dangerous drug is used. It also covers the manufacture of dangerous drugs and controlled precursors and essential chemicals, and the cultivation or culture of plants, which are sources of dangerous drugs. Section 27 addresses the criminal liability of a public officer or employee for misappropriation, misapplication, or failure to account for confiscated items and proceeds. The penalty is life imprisonment to death, a fine, and absolute perpetual disqualification from public office. Persons liable include any public officer or employee who has custody, charge, or possession of the confiscated items. The elements of this offense include the offender being a public officer or employee and having custody or possession of confiscated dangerous drugs, plant sources, precursors, or other related items or proceeds. The offender must then misappropriate, misapply, or fail to account for such items. The scope of items is broader than in previous acts. Elective officials, whether local or national, are also subject to removal and disqualification from public office if found to have benefited from proceeds of dangerous drug trafficking or received financial contributions from persons guilty of trafficking. This perpetual disqualification applies to any elective or appointive positions in the government and its corporations. This section covers the criminal liability of government officials and employees under Section 28 of Republic Act No. 9165. It provides for a special aggravating circumstance if the offender is a government official or employee involved in any unlawful act under the Comprehensive Dangerous Drugs Act of 2002. This special aggravating circumstance applies to government officials and employees involved in any unlawful act under the Comprehensive Dangerous Drugs Act of 2002. It mandates the maximum penalties for the unlawful acts they commit. We now examine the criminal liability for the planting of evidence, addressed in Section 29 of Republic Act No. 9165. This offense can now be committed by any person, unlike previous laws which focused only on government officials. The penalty prescribed is death. The elements of criminal planting of evidence include that the offender is any person and willfully planted any dangerous drug or controlled precursor and essential chemical. This expanded the scope of the offense to include any person and controlled precursors/essential chemicals. The planting must be done maliciously and surreptitiously by inserting, placing, adding, or attaching the dangerous drug or controlled precursor. It must be made in the person, house, effects, or immediate vicinity of an innocent individual to implicate or incriminate them in a violation of the Comprehensive Dangerous Drugs Act. The Supreme Court has condemned the planting of evidence, often used for extortion or harassment. While regularity in the performance of duty is presumed, it cannot prevail over the presumption of innocence. However, frame-up is considered a standard defense in drug cases. Section 30 addresses the criminal liability of officers of partnerships, corporations, associations, or other juridical entities. To incur personal liability, the accused must be a partner, president, director, manager, or other specified officer of the juridical person, which commits a violation of the act. The officer is liable as a co-principal if they consented to or knowingly tolerated the violation. The same penalty applies to officers who knowingly authorize the use of a vehicle, vessel, aircraft, or other facility owned or controlled by the entity as an instrument in the commission of drug-related offenses. For the liability involving instruments, the offender must be a specified officer. The juridical entity must own or control the instrument, and the instrument must be used in specific drug offenses. Finally, the offender must have knowingly authorized, tolerated, or consented to such use. Section 31 concerns the additional penalty if the offender is an alien. Immediately after serving their sentence, the alien offender is deported without further proceedings, unless the penalty is death. Section 32 addresses liability for violating any regulation issued by the Dangerous Drugs Board. Violations can lead to both criminal penalties, which include imprisonment and fines, and administrative sanctions imposed by the board. The elements of this violation are: the board duly issued a regulation, the regulation implements the act, the issuance is within the board's powers, and any person has violated the regulation. Section 33 covers immunity from prosecution and punishment. Immunity may be granted to any person who violated certain sections of the act, voluntarily gives information about drug syndicate violations, willingly testifies against such persons, or otherwise qualifies as a state witness. Immunity exempts the person from prosecution or punishment for the offense about which they provided information or testimony. The information or testimony given may be pleaded or proved in bar of such prosecution. Requirements for immunity include that the information and testimony are necessary for conviction, are not yet in the state's possession, can be corroborated, and the informant has no prior conviction involving moral turpitude, unless no other direct evidence is available. We continue with immunity from prosecution and punishment under Section 33 of the Act. Section 34 also discusses the termination of immunity. Immunity may not attach if the information or testimony is false or malicious, or if the informant or witness fails or refuses to testify without just cause. The effect of termination is significant. The individual becomes subject to prosecution and loses all previously accorded rights and benefits. They also cannot avail of the program for treatment and rehabilitation of drug dependence. Section 35 outlines accessory penalties for conviction. These include disqualification from exercising certain civil rights, such as parental authority, and political rights, like the right to vote or be voted for. Authorized drug testing is covered in Section 36. Drug testing may be conducted by government forensic laboratories or accredited drug testing laboratories monitored by the DOH. The DOH sets the price of drug tests. Testing methods involve a screening test and a confirmatory test. Drug test certificates are valid for 1 year and may be used for other purposes. The certificate features are also provided in the slide. Random drug testing is authorized for students in secondary and tertiary schools, pursuant to school rules and with notice to parents. The government bears the expense for these tests in both public and private schools. Random drug testing is also mandated for officers and employees of public and private offices, domestic or overseas, as per company work rules and regulations. Expenses are borne by the employer. Mandatory drug testing applies to officers and members of the military, police, and other law enforcement agencies. Note that mandatory testing for persons charged with criminal offenses or candidates for public office has been declared unconstitutional. Individuals testing positive for dangerous drugs shall be subject to prosecution for the use of dangerous drugs. This relates to Section 15 of RA number 9165. The Supreme Court in Social Justice Society versus Dangerous Drugs Board upheld random drug testing for students and employees, but declared mandatory testing for candidates for public office and persons accused of crimes unconstitutional. Section 37 addresses the issuance of false or fraudulent drug test results. The principal penalty is imprisonment of 6 years and 1 day to 12 years, and a fine of P100,000 to P500,000. Additional penalties include revocation of the license to practice profession and the closure of the drug testing center. The elements of this offense are also provided here. Section 38 covers laboratory examination or test on apprehended or arrested offenders. Requisites include apprehension or arrest for violating the act, and the officer having reasonable ground to believe the person is under the influence of dangerous drugs. Section 38's application is subject to the provisions of Section 15 and, through the latter, Section 11 of the Act. The slide also touches upon the evidentiary value of laboratory examination and test results. The laboratory examination or test on apprehended offenders under Republic Act No. 9165 requires that a positive screening result must be confirmed by a confirmatory test. If confirmed, it serves as prima facie evidence of dangerous drug use. For the results to be valid in a court of law, a positive screening test must be confirmed. Conversely, a negative result is the basis for the immediate release of a suspect, unless other evidence indicates drug use. Section 39 mandates the accreditation of drug testing centers and physicians by the Department of Health, or DOH. The DOH's duty is to ensure the capacity, competence, integrity, and stability of these centers to conduct examinations and tests. Other DOH duties related to drug testing centers include accrediting physicians for drug dependency examinations, aftercare, and follow-up programs. They must also establish a licensing and accreditation division to supervise control regulation. The DOH is also responsible for establishing, operating, and maintaining drug testing centers in government hospitals. They appoint qualified technical and other personnel for effective implementation. The old law had different provisions regarding testing centers. Section 40 outlines the records required for transactions involving dangerous drugs and precursors. Pharmacists dealing with dangerous drugs must maintain and keep original records of sales, purchases, acquisitions, and deliveries, with detailed information. The records kept by pharmacists must include specific details, such as the date of acquisition, names and addresses of buyers, prescription serial numbers, issuing practitioners' names, and the quantity and name of the dangerous drugs involved. Pharmacists must forward certified true copies of these records to the Dangerous Drugs Board within 15 days following the end of June and December each year. A copy must also be furnished to the city or municipal health officer. Physicians and other authorized practitioners must issue prescriptions for dangerous drugs in 1 original and 2 duplicate copies. The original is retained by the pharmacist, 1 copy by the buyer, and the 2nd copy by the practitioner. All prescriptions must be made on forms exclusively issued and obtained from the DOH. These forms are made of special paper, distributed in prescribed quantities, and must contain specific information, issued only to licensed practitioners. In emergency cases specified by the Dangerous Drugs Board, the prescription need not be on the prescribed form. However, the practitioner must inform the board in writing within 3 days of issuance. Prescriptions cannot be refilled. Manufacturers, wholesalers, distributors, importers, dealers, and retailers of dangerous drugs must keep records of sales, purchases, acquisitions, and deliveries. This includes the names, addresses, and licenses of persons involved in these transactions. The records must also contain the name and quantity of dangerous drugs and the date of the transaction. These records are subject to review by the Dangerous Drugs Board at any time. Section 41 addresses the involvement of the family in the fight against dangerous drugs. The family, as the basic unit of Filipino society, bears the primary responsibility for education on the ill effects of drugs and monitoring susceptible members. Student councils in all elementary, secondary, and tertiary schools must include programs in their activities focused on the prevention and deterrence of dangerous drug use. They should also facilitate referral for treatment and rehabilitation of students with drug dependence. Section 43 mandates that instruction on drug abuse prevention and control must be integrated into the curricula of all public and private schools, from elementary to tertiary levels, as well as in non-formal and informal learning systems. Heads, supervisors, and teachers of schools are considered persons in authority under Section 44. They are vested with the power to apprehend or arrest violators of Article 2 of the Comprehensive Dangerous Drugs Act of 2002. This power applies if the violations occur either in the school or its immediate vicinity, or if the educators are in attendance at any school or class function in their official capacity, even beyond the immediate vicinity. Section 45 requires the DepEd, CHED, and TESDA, with the DDB's assistance, to develop, publish, and distribute educational materials on dangerous drugs to students, faculty, parents, and the community. Section 46 establishes the Special Drug Education Center. The DILG, NYC, and DSWD must set up these centers in each provincial office for out-of-school youth and street children. They should sponsor drug prevention programs and information campaigns. The state promotes a drug-free workplace through a tripartite approach, as outlined in Section 47. The DOL must adopt a national drug abuse prevention program in the workplace, mandatory for private companies with 10 or more employees. The National Drug Abuse Prevention Program in the workplace mandates the drafting and adoption of company policies against drug use and requires consultation and coordination with the DOLE, labor and employer organizations. Section 48 mandates the DDB and DOLE to formulate guidelines for the National Drug-Free Workplace Program. Funding for its implementation is to be included in the Annual General Appropriations Act. Section 49 requires labor organizations and private sector partners to develop joint continuing programs and information campaigns for laborers to maintain a drug-free workplace. These programs should be included in their agreements. Government assistance, under Section 50, entails appropriate government and law enforcement agencies providing technical assistance, such as seminars and information dissemination campaigns, to labor organizations and private sector partners. Local government units are encouraged by Section 51 to appropriate a substantial portion of their annual budgets to drug enforcement. Priority should be given to preventative or educational programs and the rehabilitation or treatment of drug dependents. Section 52 addresses the abatement of drug-related public nuisances. A place or premise used twice or more for the unlawful sale or delivery of dangerous drugs may be abated. A complaint must be filed with an administrative board established by ordinance. The process for abatement includes giving the owner written notice and allowing them to present evidence during the hearing. The administrative board may then declare the place a public nuisance if warranted. Section 53 discusses the effect of the board declaration. It results in an immediate prohibition of any business or activity on the premises conducive to such nuisance for up to 1 year. This does not prejudice the right to proceed under the Civil Code against any public nuisance. We continue to cover the voluntary submission of a drug dependent to confinement, treatment, and rehabilitation, as per Section 54 of Republic Act No. 9165, the Comprehensive Dangerous Drugs Act of 2002. Upon application, the board presents the matter to the court, which orders the applicant to be examined for drug dependency. If a DOH-accredited physician certifies the applicant is dependent, the court mandates at least 6 months of treatment and rehabilitation. Confinement should not exceed 1 year. After this period, the court determines if further confinement is necessary for the welfare of the dependent and their family or the community. Special procedures for minor drug dependents are no longer required. Exemption from criminal liability under the Voluntary Submission Program requires that the offender is a drug dependent who voluntarily submits for confinement, treatment, and rehabilitation. They must also comply with the center's rules and the aftercare and follow-up program. Additional requisites include never having been charged or convicted of certain offenses. If the dependent escapes but surrenders within 1 week, they retain exemption. The dependent must not pose a serious danger to themselves, their family, or the community. Temporary release is granted upon the center's certification that the drug dependent may be released. The court orders release conditionally, requiring the dependent to report for aftercare and follow-up treatment, including urine testing, for up to 18 months. If the dependent is certified rehabilitated during aftercare, the court may discharge them. If further treatment is required during the aftercare period, the dependent will be recommitted for confinement. They may later be certified again for temporary release. Probation and community service are available for a drug dependent discharged as rehabilitated but not qualifying for exemption from criminal liability. They may be charged, placed on probation, and undergo community service instead of imprisonment or fine. A drug dependent is prosecuted like any other offender if they are not rehabilitated after a second commitment under the voluntary submission program. This occurs with the recommendation of the board, as per Section 58 of Representative Act No. 9165. If a drug dependent under the voluntary submission program escapes, they may voluntarily submit for recommitment or be surrendered within 1 week by a relative. Failure to do so leads to a court order for recommitment. If an escapee fails to surrender within 1 week, the board applies to the court for a recommitment order. Subsequent escape after recommitment leads to charging for violation of Section 15, forfeiting exemption from criminal liability. Records of a drug dependent's confinement or commitment under the voluntary submission program are confidential. They are inadmissible for any purpose, except to determine the number of times the dependent voluntarily submitted or was committed. Compulsory confinement applies to a drug dependent who refuses to apply for the voluntary program, provided they are determined to be dependent. A petition for confinement may be filed by the board or its representative with the regional trial court. The court sets a hearing date and orders an examination by DOH-accredited physicians. If found dependent, the court orders commitment to a DOH-supervised treatment and rehabilitation center, with the order issued no later than 15 days from filing the petition. Compulsory submission for treatment applies if a charged drug dependent faces an imprisonment penalty of less than 6 years and 1 day. The prosecutor or court must find the subject to be a drug dependent and may suspend proceedings to transmit records to the board. Compulsory submission of a drug dependent charged with an offense to treatment and rehabilitation requires the Dangerous Drugs Board to determine that public interest necessitates commitment to a treatment center. Proceedings after compulsory commitment include the head of the center submitting a written report on treatment progress to the court every 4 months or as required. The court then decides on discharge upon certification of rehabilitation. After discharge from rehabilitation, prosecution for the offense may be instituted or continued. If convicted, the dependent receives full credit for the period confined if certified for maintaining good behavior by the center. An exception applies for violations of Section 15 if the accused is not a recidivist. The penalty is deemed served upon release after certification of rehabilitation by the center and the board. The prescriptive period for offenses committed by a drug dependent under compulsory submission is suspended during detention or confinement. If a dependent escapes, there is a procedure for recommitment. An escapee can resubmit or be surrendered by a relative within 1 week for recommitment. If they fail to do so, the board applies for a recommitment order, which the court issues upon proof of prior commitment. If the dependent escapes again after recommitment, they lose the exemption from criminal liability for dangerous drug use. A dependent discharged after a second commitment, if not rehabilitated, faces penalties under Section 15 upon conviction. The judicial and medical records of a rehabilitated and discharged drug dependent under the compulsory submission program are confidential and inadmissible, except to count the number of submissions or commitments. The prosecutor is duty-bound to prepare the appropriate petition in all proceedings arising from the Comprehensive Dangerous Drugs Act of 2002. The requisites for the suspension of sentence of a first-time minor offender, over 15 but not more than 18 at judgment time, include being found guilty of a Section 11 offense. Other requisites for suspension of sentence are no previous conviction for certain offenses or commitment to a center, and a favorable recommendation from the board for sentence suspension. For minors under 15 at the time of the offense, the Child and Youth Welfare Code applies alongside this section's provisions. The law supersedes previous rules regarding minors under 16. The privilege mitigating circumstance of minority was previously held inapplicable to prosecutions under the Dangerous Drugs Act of 1972, but relevant provisions of the Revised Penal Code are now considered suppletory. Proceedings for suspension of sentence and probation are initiated after the offender is determined to be a minor first offender, in accordance with the law. Upon the board's recommendation, the court commits the accused under a suspended sentence to a center or physician for at least 6 months, with an aftercare program of up to 18 months. This section covers the discharge of a first-time minor offender after complying with the conditions of their suspended sentence, referencing Republic Act No. 9165. While under suspended sentence, the offender is supervised by the board and the DOH, with conditions set by the court for a period of 6 to 18 months. Compliance leads to final discharge and dismissal of all proceedings upon the board's recommendation. Upon dismissal, the court orders the expunging of all official records, except a confidential record with the DOJ, restoring the accused to their status before the case, making them immune from perjury or concealment related to the case. The privilege of a suspended sentence is available only once for a first-time minor offender who is a drug dependent, over 15 but not more than 18 at the time of judgment, and has not previously availed of this privilege. The court pronounces judgment of conviction if the offender is a drug dependent, a first-time offender, over 15 but not more than 18 at judgment time, and other circumstances apply, leading to serving the sentence like any other convict. The sentence is also promulgated if the accused has already availed of suspended sentence benefits or violated any of the conditions of the suspended sentence, including rules of supervision or confinement. Probation or community service may be imposed for a first-time minor offender in lieu of imprisonment. Probation is possible when a sentence is pronounced, and time in the center is deducted if imprisonment is required. The court has the discretion to grant probation, even if the sentence is higher than that under existing probation law. The board, DOH, and other agencies supervise the probation. If the accused complies with probation conditions, the board recommends termination, and the court issues an order for final discharge of the probationer. Community service may be imposed if a sentence has been pronounced, with the period spent in the center deducted from the service time if imprisonment is required. The court can impose community service upon the accused under conditions it determines, based on the board's recommendation. This applies only to violators of Section 15 of the Act. If the accused complies with community service, the board reports on compliance under their supervision. The court may then extend the service or order a final discharge. In cases of probation or community service, judicial records are kept confidential. They are inadmissible except to determine if the accused is a first offender. An order of discharge restores the accused to their status prior to the case. They are then immune from charges of perjury or misrepresentation for failing to disclose the case or related facts. The Department of Justice keeps a confidential record of suspension proceedings, which can only be used to determine if a person is a first-time minor offender. We now cover the liability of a person who violates the confidentiality of records under Republic Act No. 9165. The penalty for this violation can range from 6 months and 1 day to 6 years of imprisonment, along with a fine. The elements of violating the confidentiality of records include an offender having custody of, access to, or possession of confidential records pertaining to a drug dependent under voluntary submission programs. A special aggravating circumstance is if the offender is a government official or employee, which can raise the penalty to the maximum and include perpetual disqualification from public office. The video also addresses the liability of a parent, spouse, or guardian who refuses to cooperate with the board or any concerned agency in the treatment and rehabilitation of a minor drug dependent, resulting in contempt of court. Liability is incurred when a parent, spouse, or guardian of a minor drug dependent prevents or delays aftercare, follow-up, or other programs, whether under voluntary or compulsory submission. The cost sharing in the treatment and rehabilitation of a drug dependent involves certain relatives within the 4th degree of consanguinity. The Department of Social Welfare and Development sets guidelines based on the family's economic status. Treatment and rehabilitation centers are covered under Section 75 of Republic Act No. 9165. Existing centers maintained by the National Bureau of Investigation and Philippine National Police are to be managed by the Department of Health. Measures to enlarge the network of centers include assisting and supporting the establishment of private centers eligible for grants. Additionally, the government supports the establishment of regional treatment centers. The Department of Health's responsibilities include overseeing the integration, coordination, and supervision of all drug rehabilitation, intervention, aftercare, and follow-up programs, projects, and activities. The DOH is also responsible for charging reasonable fees for drug dependency examinations and other services, with the income accruing to the board. They also license, accredit, establish, and maintain drug test networks and laboratories. Other DOH responsibilities include encouraging and accrediting private centers and promulgating rules for their establishment. The DOH can also order the closure of a center if it violates the Comprehensive Dangerous Drugs Act of 2002. The Dangerous Drugs Board is the policy-making and strategy-formulating body for drug prevention and control. It is under the Office of the President and develops and adopts a national drug abuse prevention and control strategy. The board's permanent members include a chairman with the rank of a secretary and 2 members with the rank of undersecretary, all serving terms of 6 years after their initial staggered terms. The board also includes several ex officio members, such as the secretaries or their representatives from the Departments of Justice, Health, National Defense, Finance, and Labor and Employment. More ex officio members are the secretaries of the Department of the Interior and Local Government, Social Welfare and Development, Foreign Affairs, Education, the chairman of the Commission on Higher Education, and the Director General of the PDEA. The regular members of the board include the president of the Integrated Bar of the Philippines and a chairman or president of a non-government organization involved in the anti-drug campaign, appointed by the president of the Philippines. Permanent members must have at least 7 years of training and experience in dangerous drugs or in fields such as law, medicine, criminology, psychology, or social work. The chairman is also designated by the president of the Philippines. Cabinet secretaries, who are board members, may designate a permanent representative no lower than an undersecretary. All board members and permanent consultants receive a per diem for meetings attended. The board meets once a week, or as often as necessary at the discretion of the chairman, or at the call of any 4 other members. A quorum requires the presence of 9 members. The Secretariat of the Board is headed by an executive director with the rank of an undersecretary, who must possess adequate knowledge and experience in fields related to dangerous drugs and social work. The executive director acts as the secretary of the board and administrative officer of the Secretariat, performing assigned duties. The Secretariat includes divisions for policy studies, preventative education, legal affairs, and administration. The Secretariat also has 2 deputies executive director for administration and operations with the ranks of assistant secretary. They must also have adequate knowledge and experience in dangerous drugs and related fields. Members of the board secretariat are appointed by the president upon the board's recommendation. Their salaries correspond to positions as prescribed by the Salary Standardization Law as career service officers. The board's duties include formulating, developing, and establishing a comprehensive, integrated, unified, and balanced national drug use prevention and control strategy. The board also promulgates necessary rules and regulations, including those for the safekeeping and disposition of dangerous drugs, and prescribes administrative remedies for violations. Additional powers include initiating, conducting, and supporting policy studies, program monitoring, evaluations, and scientific research on drug prevention and control measures. The board also runs educational programs and information drives to disseminate factual data on the hazards and prevention of illegal drug use to the public and coordinates with institutions of learning. It coordinates with national and local enforcement agencies for educational campaigns and conducts special trainings for law enforcement officers, members of the judiciary, and prosecutors in coordination with the Supreme Court. The board formulates a national treatment and rehabilitation program, including aftercare and community service programs. It also develops drug abuse prevention programs in the workplace, with the DOLE and other groups. The board can initiate closure proceedings against non-accredited or substandard rehabilitation centers based on reports of human rights violations or inadequate medical assistance. The PDEA implements the closure. The board's powers and duties include receiving, gathering, collecting, and evaluating information on the importation, exportation, production, manufacture, sale, stocks, seizures of, and estimated need for dangerous drugs and controlled precursors and essential chemicals. The board also compiles statistics on the importation, exportation, manufacture, stocks, seizures, and estimated need of these drugs, consistent with international commitments and requirements from global narcotics organizations. Another duty involves international networking, coordinating with drug control agencies and organizations, and implementing international conventions and agreements approved by the Philippine Congress. This is key for global cooperation. The board receives, administers, and disposes of trusts, legacies, gifts, and donations of property for the benefit of government and private rehabilitation centers, subject to donor stipulations. It also issues guidelines for the approval or disapproval of applications for voluntary treatment, rehabilitation, or confinement, and creates rules and regulations for the application process and its enforcement. The board regulates the importation, distribution, production, manufacture, compounding, prescription, dispensing, and sale of dangerous drugs. It sets guidelines in coordination with other agencies based on medical and research needs. The board is also tasked with developing the controlled delivery scheme to address the transshipment of dangerous drugs, aiming to neutralize transnational crime syndicates involved in illegal trafficking. It can recommend the revocation of a practitioner's professional license if they are an owner, co-owner, lessee, or employee who knowingly participates in, consents to, tolerates, or abets violations of the Act. The board is responsible for appointing technical, administrative, and other necessary personnel, subject to civil service laws, for the effective implementation of the Comprehensive Dangerous Drugs Act of 2002. Regular consultation with government agencies and medical organizations ensures balanced policies and procedures on dangerous drugs. This consultation also aims to improve and facilitate the lawful use of dangerous drugs. Finally, the board submits annual and periodic reports to the President, Congress, and relevant committees, and performs other functions authorized by law or directed by the President. We continue to discuss the Philippine Drug Enforcement Agency, or PDEA, established by Republic Act No. 9165. The PDEA is the implementing arm of the Dangerous Drugs Board, responsible for the effective enforcement of all dangerous drugs and controlled precursors provisions of the Comprehensive Dangerous Drugs Act of 2002. The composition of the PDEA includes a Director General with the rank of Undersecretary, responsible for the general administration and management of the agency. There are also 2 Deputy Directors General with the rank of Assistant Secretary, one for operations and the other for administration. Common qualifications for PDEA officers require adequate knowledge, training, and experience in dangerous drugs, law enforcement, law, medicine, criminology, psychology, or social work. The Director General and deputies are appointed by the President. The organization of the PDEA involved the absorption and modification of the Secretariat of the National Drug Law Enforcement and Prevention Coordinating Center. PDEA services include intelligence and investigation, and international cooperation and foreign affairs. Additional PDEA services encompass preventative education, community involvement, plans and operations, compliance, legal and prosecution, administrative and human resources, financial management, logistics management, and internal affairs. Regional offices are responsible for implementing the Act and the agency's programs and projects. PDEA's powers and duties include implementing the National Drug Use Prevention and Control Strategy. This involves causing efficient implementation and carrying out a national drug campaign program with assistance from concerned government agencies. PDEA has drug law enforcement and investigation powers. This includes enforcing provisions related to unlawful acts and penalties involving dangerous drugs and precursors. They are also responsible for the safekeeping and disposition of seized chemicals and drugs and investigating all violators of the Drug Act. Ancillary to investigatory powers, the PDEA can administer oaths. They can also issue subpoena and subpoena ducis tecum relating to investigations of violations under the Comprehensive Dangerous Drugs Act of 2002. The PDEA has the power to effect arrests, apprehension, searches, and seizures of all violators and the effects or proceeds of the crimes as provided by law. Prosecutors and enforcement agents are authorized to possess firearms for this purpose. The PDEA is mandated to take charge and custody of dangerous drugs, controlled precursors, and essential chemicals seized, confiscated, or surrendered. This is done through any national, provincial, or local law enforcement agency if they are no longer needed for court evidence. The PDEA is also responsible for establishing forensic laboratories in each PNP office in every province and city. This is to facilitate action on seized or confiscated drugs, hastening their destruction without delay. The PDEA has the power to initiate forfeiture proceedings. This includes recommending to the Department of Justice the forfeiture of properties and other assets of individuals or corporations violating the Act and the Anti-Money Laundering Act of 2001. A key duty is to ensure the proper and effective prosecution of drug cases. This involves prosecution or causing the filing of appropriate criminal and civil cases, and assisting, supporting, and coordinating with other government agencies. The PDEA must monitor and inspect air cargo packages, parcels, and mails in the Central Post Office that suggest the possible importation of dangerous drugs or controlled chemicals. This also extends to monitoring online or cyber shops via the Internet. Additional duties include establishing eradication programs to destroy wild or illegal growth of plants used for dangerous drugs. The PDEA must also develop a nationwide organization for anti-drug abuse activities across all local government levels and non-governmental organizations. The PDEA is responsible for establishing a national drug intelligence system in cooperation with law enforcement and government agencies. This supports the apprehension of big-time drug lords, requiring data and information on dangerous drugs, controlled precursors, and essential chemicals. Another duty is to maintain international linkages. This involves close coordination and cooperation with international drug control and administration agencies and organizations, as well as implementing international agreements to which the Philippines is a signatory. The PDEA must promote an efficient special enforcement unit. This unit can conduct investigations, file charges, and transmit evidence. Its members may possess suitable firearms without a previous special permit for protection during duties. PDEA also has the power to require reports from private hospitals, clinics, doctors, dentists, and other practitioners. This is for data and information concerning dangerous drugs, controlled precursors, and essential chemicals they have attended to, in coordination with the board. The PDEA facilitates the issuance of necessary guidelines, rules, and regulations for the proper implementation of the Act, coordinating with the board. Furthermore, they implement a national campaign for drug prevention and control programs. The PDEA's final powers and duties include submitting annual and periodic reports to the board as required. They also perform other functions authorized by existing laws, directed by the President, or recommended by the congressional committees concerned. The PDEA Academy, established under the Act, is responsible for the recruitment and training of all PDEA agents and personnel. Graduates will comprise the PDEA's operating units after the 5-year transition period. Recruits for the PDEA Academy must be at least 21 years old, of proven integrity and honesty, and a baccalaureate degree holder. The Academy is headed by a superintendent with the rank of director, appointed by the PDEA Director General. The creation of the PDEA abolished the narcotics group of the PNP, the narcotics division of the NBI, and the Customs Narcotics Interdiction Unit. Personnel from these units may continue their service with PDEA temporarily, subject to screening. Personnel transferred to PDEA receive similar rank, salary, and privileges. This transfer, absorption, and integration must take effect within 18 months of the Act's effectivity, but absorbed personnel have up to 5 years to decide to join the PDEA permanently. The investigatory powers of the NBI and PNP on other crimes are not diminished. However, when an investigation involves the Comprehensive Dangerous Drugs Act, the PDEA becomes the lead agency, requiring immediate transfer of the case to them. The Dangerous Drugs Board and PDEA receive funding from current year's appropriations of integrated drug law enforcement units. Subsequent necessary sums are included in the Annual General Appropriations Act for continued implementation of the Act. A special account includes fines, fees, and income from the Act, plus 10% of unclaimed sweepstakes and lotto prizes, at least P12 million yearly from PCSO. Fines are remitted to the board within 30 days of final court decision, and 50% of funds are for government rehabilitation centers. 5 million pesos a month from PAGCOR's 50% share of its national government income is set aside for establishing, maintaining, and operating drug rehabilitation centers. This amount is automatically remitted to and dispersed by the Dangerous Drugs Board. The board manages funds for the Act's objectives and submits annual and periodic reports to the President and Congress, presiding officers within 15 days of the regular session opening. Section 88 of Republic Act No. 9165 details the management of funds and requires an annual report from the board and the PDEA. This article, Article 10, covers appropriations, management of funds, and annual report for the Comprehensive Dangerous Drugs Act of 2002. Section 89 addresses the auditing of accounts and expenses. All accounts and expenses of the Board and the PDEA are subject to audit by the Commission on Audit or its duly authorized representative. Article 11 covers jurisdiction over dangerous drugs cases. The Supreme Court designates special courts from existing regional trial courts to exclusively try violations of the Act, basing the number on population and pending cases. The Department of Justice designates special prosecutors for these cases. Preliminary investigations must conclude within 30 days. If probable cause is found by a public prosecutor, the information must be filed within 24 hours. If a judge conducts the preliminary investigation and finds probable cause, the proper prosecutor must file the information within 48 hours of receiving the case records. The trial of a drug case must be completed within 60 days from the filing of the information. A decision on the case must be rendered within 15 days of its submission for resolution. Section 91 covers the responsibility and liability of government officials in testifying as prosecution witnesses. Failure or refusal to appear as a witness results in a penalty of 12 years and 1 day to 20 years imprisonment and a fine of P500,000. The immediate superior of a failing witness is liable if they do not exert reasonable effort to present the witness, despite due notice. The penalty is 2 months and 1 day to 6 years imprisonment, a fine, and perpetual disqualification from public office. The immediate superior is also liable for failing to notify the court of an order to transfer or reassign a witness. The penalties are the same as the previous scene. A witness cannot be transferred or reassigned to another territorial jurisdiction during the case's pendency, except for compelling reasons. The immediate superior avoids criminal liability by notifying the court within 24 hours of the approval of the transfer order. We continue to discuss the responsibility and liability of law enforcement and other government officials for testifying as prosecution witnesses in dangerous drug cases under the Comprehensive Dangerous Drugs Act of 2002. We now look at the elements of refusal or neglect to appear as a witness in drug cases. This applies if an offender is a member of a law enforcement agency or government employee who is duly noticed and required to appear, but fails or refuses to do so without valid reason. The elements of failure to exert reasonable efforts to secure a subordinate's appearance include the offender being the immediate superior, the subordinate being required to appear, and the superior failing to exert reasonable effort despite notification. Next are the elements of unlawful reassignment or transfer of a subordinate. The offender must be the immediate superior of a subordinate, who is duly notified and required to appear as a witness for the prosecution in Comprehensive Dangerous Drugs Act violations. Furthermore, the superior must be notified that the subordinate is required to appear. Despite this notice, the superior must transfer or reassign the subordinate to another government office located in a different territorial jurisdiction during the case's pendency. A concerned employee may be transferred for compelling reasons, but the immediate superior must notify the court of this order within 24 hours of approval. The element of unlawful reassignment also includes the offender failing to notify the court of such a transfer order. We now address the delay and bungling in the prosecution of drug cases. The penalty for this is 12 years and 1 day to 20 years, without prejudice to further prosecution under the Revised Penal Code. Persons liable include any government officer or employee tasked with the prosecution of drug-related cases. The elements of this crime include the offender causing the unsuccessful prosecution through patent laxity, inexcusable neglect, unreasonable delay, or deliberately. The Dangerous Drugs Board has the power to reclassify, add, or remove any drug from the list of dangerous drugs. Reclassification proceedings can be initiated by the PDEA or the DOH. Reclassification proceedings may also be initiated on the petition of any interested party. This includes a manufacturer of a drug, a medical society, a pharmacy association, a public interest group, a government agency, or an individual citizen. Additionally, reclassification can be initiated upon information received from law enforcement laboratories, national and local law enforcement and regulatory agencies, or other sources of information on their own initiative. Factors considered for reclassification include the actual or relative potential for abuse and scientific evidence of pharmacological effect if known. Furthermore, the state of current scientific knowledge, history, and current pattern of abuse are also factors. Other considerations include the scope, duration, and significance of abuse, risk to public health, and whether the substance is a precursor to a controlled substance. Finally, international treaty obligations are also taken into account. Notice to the general public is required for reclassification, addition, or removal from the list of dangerous drugs. This notice must be published in a newspaper of general circulation once a week for 2 consecutive weeks. In cases where a dangerous drug is reclassified as precursors and essential chemicals, the penalties for violations involving these categories shall be imposed in all pending criminal prosecutions upon conviction. We continue with the reclassification, addition, or removal of any drug from the list of dangerous drugs. When precursors and essential chemicals are reclassified as dangerous drugs, penalties for violations, upon conviction, will be imposed in all pending criminal prosecutions. If a new drug or precursor is added to the list, criminal liability only arises after 15 days from the last publication of the notice of addition of the new drug to the list of dangerous drugs. In case of removal of a drug, all persons convicted or detained for the use or possession of the removed drug shall be automatically released. All pending criminal prosecutions involving the removed drug are to be dismissed. The Board must submit to Congress, within 5 days of promulgation, a detailed reclassification, addition, or removal of any drug from the dangerous drugs list. The Dangerous Drugs Board, in consultation with various government agencies, promulgates the implementing rules and regulations for the Comprehensive Dangerous Drugs Act of 2002. This should be done within 60 days from the Act's effectivity. The Congressional Oversight Committee on Dangerous Drugs is composed of 7 members from the Senate and 7 from the House of Representatives, appointed based on proportional representation. Senate members are appointed by the Senate President, with at least 2 representing the minority. House members are appointed by the Speaker, similarly with at least 2 representing the minority. The powers and functions of the Oversight Committee include setting guidelines for monitoring the Act's implementation and ensuring transparency by requiring reports from concerned government agencies. The committee also approves its budget, submits periodic reports to the President and Congress, determines weaknesses in the law, and recommends remedial legislation or executive measures. The Oversight Committee can adopt its internal rules of procedure, conduct hearings, receive testimonies and reports, and invite or summon officials and citizens to testify. The committee may also require the production of documents or materials via subpoena ducis tecum. A secretariat assists the committee, and personnel from the Senate and House, along with consultants, may be retained. The Congressional Oversight Committee's term of existence is 10 years from the Act's effectivity, extendable by a joint concurrent resolution. Initial funding is charged against Senate appropriations, with subsequent amounts included in the General Appropriations Act. In general, the provisions of the Revised Penal Code are not applicable to the Comprehensive Dangerous Drugs Act of 2002. The exception is for minor offenders. If the offender is a minor, the penalty for acts punishable by life imprisonment to death shall be reclusion perpetua to death. It is important to note that life imprisonment is different from reclusion perpetua. This video will examine the anatomy of the ecosystem of Republic Act number 9165, the Comprehensive Dangerous Drugs Act of 2002. We'll explore its statutory elements, penalties, procedural mandates, and constitutional checks, which form the legal blueprint of this act. RA 9165 marked a significant paradigm shift from the repealed RA 6425, moving from simple drug regulation to an objective of eradication. The new act explicitly excludes the Revised Penal Code and consolidates all illicit substances under a single dangerous drugs classification. Its policy mandate emphasizes an unrelenting campaign against drug trafficking and sustainable treatment and rehabilitation. Section 3 defines the actors within the illicit network. At the apex are the drug syndicate and the financier. The enablers include the protector/coddler and the organizer/manager. Finally, the ground operations involve the pusher and the employee. Macro offenses such as importation, manufacture, and sale, trading, or delivery carry a severe penalty base of life imprisonment to death, plus a fine. For importation, the quantity and purity of the dangerous drugs are immaterial. Authorized practitioners are exempt from the manufacture offense. A valid buy-bust operation does not require a formal complaint, prior surveillance, or emission order. For the end user, illegal possession overrides illegal use. Illegal possession requires actual or constructive control and intent to possess. Finding drugs in a house is prima facie evidence of knowledge. Illegal use applies only if the offender is not found to have drugs in their possession. leading to rehabilitation for the first offense and potential imprisonment for the second. Spatial offenses target the trade's infrastructure. Zone 1 covers dens, dives, or resorts, where owners face heavy penalties. Zone 2 addresses clandestine laboratories and the diversion of essential chemicals. Zone 3 deals with cultivation, where the land can be escheated if the owner fails to prove absence of knowledge. Section 11 outlines the quantity heat map, setting the threshold for the most severe penalties, ranging from life imprisonment to death. The quantity and purity determine the penalty bracket. However, for sale or importation offenses, the quantity is immaterial to the penalty. Statutory aggravating circumstances, or force multipliers, increase the severity of penalties. These include exploiting the vulnerable, such as victims and minors, and committing offenses within 100 meters of schools, known as the sanctuary. Offenses during social gatherings and betrayal by public officials are also aggravating circumstances. Buy-bust operations rely on the valid entrapment mechanism, a legally sanctioned form of entrapment. No formal complaint, mission order, or prior surveillance is mandated. However, the Supreme Court provides a judicial warning, acknowledging that buy-busts are susceptible to mistake, harassment, and extortion, making the defense of frame-up common. Section 21 mandates the golden thread of evidence requirements. Immediate inventory and photography of seized items must be conducted at the apprehension node. A mandatory quad of witnesses, including the accused, an elected public official, and representatives from the DOJ and the media, must be present. Non-compliance is excusable only if the integrity of the evidence is preserved. The countdown to destruction timeline in Section 21 continues with immediate certification from a forensic lab. Within 72 hours of filing the criminal case, the court must conduct an ocular inspection. Destruction of the drugs must follow within 24 hours, with a representative sample retained for trial. The presence of the accused at destruction does not imply guilt. Section 29 addresses planting evidence, a malicious act of inserting dangerous drugs on an innocent individual. It applies to any person and is punishable by the ultimate penalty of death. Section 27 is a related crime for public officers who misappropriate or fail to account for seized drugs, facing life imprisonment and disqualification. The drug testing matrix in Section 36 outlines valid random testing for students and employees and mandatory testing for law enforcement. The judicial veto has struck down mandatory testing for candidates for public office and the accused in criminal cases, upholding constitutional rights to privacy and protection against self-incrimination. Section 23, the statutory prohibition against plea bargaining, was ruled unconstitutional by the Supreme Court in the Estepona v. Labrigo case in 2017. The judicial check recognized plea bargaining as a rule of procedure under the judiciary's exclusive authority, protecting the institutional independence of the courts and ensuring speedy case disposition. RA 9165 operates as an ecosystem balancing the sword of the state, enforcement, and the shield of procedure, due process. Despite its immense penal power, it remains subservient to the mechanisms of procedural integrity and the Bill of Rights, protected by judicial supremacy and critical procedural safeguards like the golden thread of evidence.
All right, let's jump right into this explainer. Today, we're unpacking how Philippine law essentially weaves this massive, highly sophisticated net to capture an entire criminal underworld. We're looking at the Comprehensive Dangerous Drugs Act of 2002, also known as Republic Act 9165. Now, this isn't just some boring list of rules. It's a meticulously engineered blueprint, and its goal? To completely dismantle a complex, illicit industry from the very top all the way down. To make sense of this pretty dense legal syllabus, we're going to break it down into 6 clear parts. We've got the shift in the law, the criminal ecosystem, operations and evidence, the supply chain, dens and distribution, and finally, possession and penalties. By the end of this, you'll see exactly how the justice system maps out the entire illicit trade. So, let's kick things off with part 1, the shift in the law, specifically looking at the jump from 1972 to the 2002 Comprehensive Act. Looking at the timeline, you can really see the evolution here. It's fascinating, because early penal codes had to be drastically upgraded to handle modern narcotics. Originally, drug offenses were just tucked away under a few articles in the Revised Penal Code. But by 1972, the landscape had totally changed, which gave us Republic Act 6425. But here's the catch. As the drug trade globalized and morphed into this highly organized, almost corporate-like entity, that 1972 law, it just couldn't keep up.
It was completely outpaced. And that brings us to 2002, where Republic Act 9165 stepped in and totally replaced the old statutes.
Now, what's absolutely crucial to grasp here is the massive shift in scope. The old law was honestly kind of limited. It mainly went after individual users, simple possession, and your street-level pushers. But the 2002 law, it's a whole different beast. It doesn't just punish the end user, it targets the entire business network. We're talking about anticipating the logistics of the trade, penalizing the handling of essential chemicals or controlled precursors needed to actually cook the drugs, and it even stretches all the way to cover modern cyber trading.
Which leads us right into Part 2, the criminal ecosystem and its cast of characters. Because the 2002 Act totally recognizes that a drug syndicate is basically a dark corporation with very specific roles. First up, we have the financier. The law literally defines this as anyone who pays for, raises, or supplies money for these illegal activities. What does that mean for you? Well, it means you don't even have to touch a single drug to face the absolute wrath of the law as long as you're funding the operation. The state realized that cutting off the cash flow is just as vital as seizing the physical product.
Next, we've got the protector or coddler, and this puts a huge target on the backs of those who use their power to harbor criminals and help them dodge justice. The legal definition hits hard here. It's a person of influence who knowingly and willfully uses their position to shield a violator or help them escape. It's a direct attack on the corruption that historically allowed these syndicates to just operate with total impunity.
And of course, we can't forget the pusher. But the 2002 law explicitly broadens this definition way beyond the street corner. It includes anyone acting as a broker, a dispatcher in transit, or someone moving the goods. The legal act of delivering simply means knowingly passing a dangerous drug to someone else, whether you get paid for it or not. Basically, if you facilitate the physical movement in any way, you are part of the ecosystem.
All right, moving on to Part 3, operations and evidence, specifically zeroing in on buy-busts and planting evidence. Let's see how this actually plays out in the real world.
Because the penalties we're talking about are so incredibly steep, the methods used to gather evidence, like those dramatic buy-bust entrapment operations, are heavily scrutinized. Which brings up a really crucial question. In a system with such intense punishments, what happens if evidence is planted? How does the law protect an innocent person from being framed? In the drug trade, claims of extortion or being set up are super common defenses.
Here is the real game changer. Unlike the old statutes, the 2002 Act makes planting of evidence a severe crime that applies to absolutely any person. Back in the day, the law only went after corrupt government officials or cops who planted stuff, but RA 9165 casts a much wider net. Whether you overtly or sneakily slip a dangerous drug or chemical into someone's house, their belongings, or even just their immediate vicinity with the malicious intent to implicate them, you are committing a major offense.
Let's shift gears to Part 4, the supply chain. We're looking at the whole life cycle, from importation to manufacture, way before anything ever hits the street.
The law is pretty brilliant here because it anticipates every single move. It penalizes the initial importation, the sneaky diversion of legal chemicals, right down to the actual cooking process. Look at Step 2, chemical diversion. This targets the illegal rerouting of legitimately imported chemicals, stuff that actually has normal industrial uses, into the hands of illegal drug makers. The law even considers using fake permits, misdeclaring items, or hiding behind front companies as criminal acts.
And when we get to the actual manufacturing phase, the law really shows its teeth. If a clandestine lab is booby-trapped or hiding behind the facade of a legitimate business, the penalties are severely aggravated. Plus, the absolute maximum penalties kick in if the lab is operating within 100 meters of a residential area, a church, or a school. Oh, and if minors are used in any phase of the process, forget about it. The law clearly recognizes that these labs are like ticking time bombs for the surrounding community.
Now, for Part 5, dens and distribution, or as I like to call them, the hubs of the trade. This goes beyond the supply chain and aggressively targets the physical real estate.
Maintaining a den, dive, or resort is a massive offense. Legally, this is simply defined as any place where drugs or essential chemicals are stored, sold, or used. And what's wild is the sheer power the state has here. The government can actually confiscate and escheat the property, meaning they literally seize ownership of the real estate itself if they can prove the owner intentionally let the property be used to further these crimes.
And just look at how wide the liability spreads. You absolutely do not have to be the kingpin to get caught in this net. The law deliberately holds multiple layers of people accountable. Aside from the obvious owners and financiers, even being a low-level employee, like a caretaker, a helper, or just a lookout, makes you criminally liable. And get this, even being a knowing visitor, literally just walking into the den knowing that drugs are being used there, is a direct violation of the law.
Finally, we arrive at Part 6, Possession and Penalties. Let's break down the actual thresholds of the law. Now, I'm not going to bore you by reading out every single penalty. Instead, focus on these specific threshold weights. We're talking 50 grams for shabu or meth, 500 grams for marijuana, or just 10 measly grams for heroin and cocaine. Under Section 11 of the Act, the mere act of possession, meaning you just have control over it without legal authorization, is penalized. But the second the volume hits those specific numbers on the scale, boom, the severity of the punishment maxes out, and it doesn't even matter how pure the drug is.
Oh, and here is a really fascinating did you know for you. The 2002 law actually upgraded its scope to explicitly punish cyber trading and electronic brokering. It specifically flags transactions using text messages, emails, mobile phones, or internet chat rooms. So a drug deal doesn't need to happen in some sketchy dark alley anymore. If you're brokering a deal online, the law has a specific provision waiting right there for you.
This quote from the law's declaration of policy perfectly sums up why the state engineered such an intense, comprehensive legal ecosystem. It is an unrelenting campaign designed to fight this issue from literally every angle. It's not just about slapping cuffs on the end user, it's about choking the life out of the supply chains, bankrupting the financiers, locking up the corrupt protectors, and completely dismantling the clandestine infrastructure.
Which leaves us with a pretty big question. As criminals inevitably find new ways to operate, maybe hiding deep on the dark web or inventing entirely new synthetic compounds, will this intricate web of laws be enough to catch them tomorrow? Or are we already looking at the need for an even more evolved comprehensive act? Thanks for hanging out with me for this explainer, and remember to keep questioning how the systems around us are built to maintain order.
Imagine a world where a single gram of a chemical powder, like literally less than the weight of a paperclip, can legally strip away your freedom for the rest of your life.
Right.
Imagine being handed a rule book so rigid, so deeply unforgiving that just standing in the wrong room at the wrong time presumes your guilt before you even open your mouth to defend yourself.
It's a terrifying thought.
It really is. Welcome to the Deep Dive, everyone. Today, we're exploring the Philippine Comprehensive Dangerous Drugs Act of 2002.
Or Republic Act No. 9165, officially.
Exactly. And our mission today is to really unpack how a nation legally defines, hunts down and prosecutes the illegal drug trade.
Yes.
We're going to explore the incredibly fascinating and frankly sometimes terrifying friction between draconian state power and fundamental constitutional human rights. Because looking at these legal slides, it's like reading the blueprint for a high-stakes chess match between law enforcement and drug syndicates.
It truly is a remarkable piece of legislation to dissect, because what we are really looking at here is a society's ultimate stress test.
A stress test. I like that.
Yeah, how do you balance the desperate need for public safety against the bedrock presumption of innocence? RA 9165 is arguably one of the most severe, highly specialized legal frameworks in the world when it comes to narcotics.
Well, I want to set the stage for you, the listener, because diving into this isn't just about reading a list of penalties. It's about understanding the mechanics of a war.
Exactly.
When you look at the text of this law, it's not just a set of rules, it's an active battlefield strategy. But to understand the weapons the state is using today, we kind of have to look at what they were using before. The 2002 law didn't just appear out of nowhere, right?
No, not at all. It was a massive overhaul of an older system. The original framework was Republic Act No. 6425, which was known as the Dangerous Drugs Act of 1972.
Okay, the 70s.
Right. And even before that, prior to 1972, drug offenses were actually just handled under the general criminal law, the Revised Penal Code.
Oh, really?
Yeah. Back then, Articles 190 through 194 covered things like, possession, preparing prohibited drugs, or maintaining an opium den. It was treated somewhat like standard criminal behavior.
Right. But, the world changes. The 1972 law categorized drugs into two very simple buckets, right? Like prohibited drugs and regulated drugs.
Very simple, yes.
It punished the basics: importation, sale, manufacture. But from what I'm seeing in the syllabus, by the time the late 90s and early 2000s rolled around, that 1972 law was essentially a relic.
Oh, absolutely a relic.
It was like they were running an old computer operating system, like MS-DOS or something, while the drug cartels had upgraded to gigabit internet and supercomputers. The 1972 law was built for an analog world of plant-based drugs.
Right, exactly.
And the 2002 law had to be built for the terrifying new era of synthetic chemistry.
That operating system analogy is perfect, actually. The shift to the Comprehensive Dangerous Drugs Act of 2002 wasn't merely about handing down harsher punishments, although, it certainly did do that in spades.
Yeah, we'll get to those later. They are wild.
But it was mostly about modernizing the fundamental scope of the state's reach. The state essentially declared an intensive, unrelenting campaign against drug trafficking. But they also had to acknowledge the medical reality, right?
What do you mean?
Well, they explicitly included a policy to balance this war with the need for legitimate medical treatments. People with actual medical needs shouldn't be prevented from getting adequate medications, and there needed to be a framework for rehabilitating users.
Okay, let's unpack this concept of the operating system upgrade, because there is a massive legal shift that happens here, which completely changes the game for anyone accused of a crime.
Yes, Section 98.
Right. Under the old 1972 law, provisions of the General Revised Penal Code were considered what lawyers call suppletory, like a backup or a gap filler.
Exactly.
But under the 2002 law, Section 98 expressly strips that away. It says the provisions of the Revised Penal Code are largely inapplicable, except for minor offenders. No, I have to push back on this a bit. If the standard penal code doesn't apply, does that mean if someone committed a drug offense under extreme duress, like, let's say someone literally held a gun to their head and forced them to carry a bag of drugs, they can't use the normal legal defenses found in the penal code? Are we just stripping away the usual legal safety nets for the accused?
That is precisely the gravity of Section 98. When a statute says the General Penal Code is inapplicable, it means it's establishing a highly specialized, self-contained legal universe.
Wow.
Yeah, so the mitigating or modifying circumstances you might usually rely on in a standard criminal trial, things that could lessen a sentence, like provocation, or potentially certain forms of duress, they are often completely off the table unless this specific special law provides for them.
That's intense.
It is. The law is designed to be rigid. Historically, the Supreme Court has highlighted this policy of imposing strict penalties without the usual wiggle room. The 2002 law ensures that drug offenses are treated with a unique, unyielding severity. It's basically a closed system.
That is chilling. It's a legal system that basically says, we don't care about the nuance of your situation. If you broke this specific rule, the hammer falls.
Pretty much.
And we can see this modernization, this shift in perspective in how they view the users themselves. Look at how they define drug dependence. The old 1972 law had a very bare bones definition. It just said it was a state of psychic or physical dependence from using a drug.
Yes, it was purely a physiological description, very basic.
Right.
But the 2002 law redefines drug dependence by aligning it directly with the World Health Organization's modern definition. It describes it as a cluster of physiological, behavioral, and cognitive phenomena.
So treating it more like a disease model.
Exactly.
Yeah.
It emphasizes that the use of a psychoactive drug takes on a much higher priority for a given individual than other behaviors that once had greater value. It recognizes addiction as a compulsion, a profound difficulty in controlling substance-taking behavior.
So it's sort of a double-edged sword. On one hand, the law becomes incredibly rigid and punitive, stripping away general criminal defenses. But on the other hand, its understanding of addiction becomes far more sophisticated and medically accurate.
That's a great way to summarize it. The state realized that to fight a modernized enemy, they had to dramatically expand their legal vocabulary. You simply cannot prosecute what you cannot legally define.
Right.
The 1972 law didn't specifically name modern synthetic drugs in its primary text. The 2002 law completely changes that.
Which brings us to the actual lexicon of this law.
Yep.
Section 3 is basically an entirely new dictionary for law enforcement. They start explicitly naming the new enemies. We see methamphetamine hydrochloride, known locally as shabu, ice, or meth.
They had to name them because synthetic drugs are the new front lines. But they also overhauled the broad definition of dangerous drugs by annexing the massive schedules from the 1961 UN Single Convention on Narcotic Drugs and the 1971 Convention on Psychotropic Substances.
Oh, so they tied it to international law.
Exactly. They tied the domestic law to international treaties so that as the global community identified new threats, the Philippine law was already primed to recognize them.
That's smart. But they didn't just stop at the final product, which is what I find so fascinating. They went after the raw ingredients.
The precursors, yeah.
Right. The law targets what they call controlled precursors and essential chemicals. This is like trying to shut down illegal bakeries by outlawing flour and yeast. If you can't catch the meth on the street, you catch the chemicals used to make the meth in the warehouse.
Precisely. This is about targeting the supply chain before the drug even exists. And because of this, they had to introduce a brand new legal concept called chemical diversion.
Okay, explain chemical diversion to me. How does that actually work in practice?
So imagine a legitimate pharmaceutical company. They legally import massive barrels of a precursor chemical to make, say, perfectly legal cough syrup. Chemical diversion occurs when someone inside that company, or maybe a middleman, takes those legal chemicals and siphons them off, diverts them, to a jungle laboratory manufacturing illegal drugs.
Oh, wow.
And the law explicitly criminalizes the acts used to hide this, like fraudulent packaging, relabeling, using front companies, or committing mail fraud to conceal where these chemicals are actually going.
So the crime isn't just making the drug. The crime is lying on a shipping manifest about where your cough syrup ingredients are going.
Exactly. You're part of the machinery.
And speaking of jungle laboratories, the law goes incredibly deep into defining the clandestine laboratory. It's any facility used for the illegal manufacture of any dangerous drug or controlled precursor. But the definition of laboratory equipment is what really caught my eye.
Oh, it's very thorough.
It is hyper-specific. We're talking reaction vessels, preparative and purifying equipment, fermenters, separatory funnels, flasks, heating mantles, and gas generators.
And under Section 10 of the law, it is a crime to manufacture, deliver, or possess with intent to deliver this specific equipment.
Wait, really? Just the equipment?
Just the equipment. But there is a crucial safeguard here. A mental state requirement, what lawyers call mens rea.
Okay, explain that.
You have to deliver this equipment knowing, or under circumstances where you reasonably should know, that it will be used to manufacture or prepare dangerous drugs.
So if I run a legitimate science supply store and someone comes in to buy a bunch of separatory funnels and flasks, I'm not automatically a criminal.
Correct. You're fine. But if that same person comes in paying with stacks of unmarked cash, wearing a ski mask, and asks for industrial-scale heating mantles to be delivered to an abandoned warehouse in the middle of the night.
Right, okay.
Under the law, you reasonably should have known those weren't for a high school chemistry class. You could be prosecuted for delivering the equipment.
That puts an incredible burden of vigilance on legitimate businesses. But here is where it gets really mind-blowing. Think about the year 2002. Think about what technology looked like back then.
Dial-up internet.
Exactly. And yet, look at the legal definition of trading in this act. Trading is defined as transactions involving illegal trafficking, including through the use of electronic devices. It specifically lists text messages, emails, mobile phones, the internet, instant messengers, and chat rooms. In 2002,
It's pretty wild.
they realized that drug deals weren't just happening in dark alleyways with briefcases anymore. They were happening on Nokia brick phones and Yahoo Messenger.
It showed remarkable foresight by the legislature, honestly. They understood that the digital architecture of the early 2000s was going to become the new highway for illegal trade. So they expanded their net to capture the medium of the transaction, not just the physical exchange.
Okay, so the state has built this massive, highly specific net. They've defined the precursors, the glassware, the chat rooms, the exact chemical compounds. But, I mean, a net is only as intimidating as what happens when you get caught in it.
True.
And that brings us to the terrifying part of this law.
Yeah.
The penalties. We are talking about the heavy hand of the state.
And heavy hand is almost an understatement. The penalties are staggering. Let's start with Section 4, the importation of dangerous drugs.
Okay.
If you bring dangerous drugs into the Philippines without authority of law, the penalty is life imprisonment to death, at a fine ranging from 500,000 to 10 million pesos.
Life imprisonment to death. Let that sink in for a second. And what's crazy is that quantity and purity are entirely immaterial for importation.
Absolutely immaterial.
It doesn't matter if you are smuggling in a shipping container full of pure cocaine or if you have a single gram of shabu hidden in your shoe at the airport. The charge is exactly the same, life to death.
That's right. The act of crossing the sovereign border with the substance is the ultimate crime. And historically, the Supreme Court has had to define exactly what constitutes importing.
How so?
Well, there are landmark principles establishing that mere possession on a foreign merchant vessel anchored in a Philippine port after arriving directly from a foreign port is punishable as illegal importation.
Even if you haven't stepped off the boat?
Even then, unless it can be proven, the vessel is strictly in transit and the drugs aren't destined for the country. The moment it enters the territorial jurisdiction, the trap springs.
And it's not just the person physically carrying the bag who gets hit with this penalty, right? The law targets the entire corporate structure of a drug syndicate.
Yes, it explicitly goes after the higher-ups.
It specifically names the organizer, the manager, and the financier. So if you are the guy in a penthouse somewhere just wiring money to fund a smuggling operation, you are facing the exact same life-to-death penalty as the courier on the ground.
And it goes even further into the shadows with the concept of the protector, or coddler. This is a vital legal concept in RA 9165.
A coddler, that's a weird word for it.
It is, but legally, a protector or coddler is someone who uses their influence, power, or position to shield a violator.
Paint a picture of a protector for me. Who are we talking about here?
Okay. It could be a corrupt local town mayor. This mayor doesn't touch the drugs, doesn't sell the drugs, and might not even take a direct cut of the drug money. But they know a syndicate is operating a clandestine lab in their town. So when the local police chief asks for permission to raid the warehouse, the mayor says, "No, leave that warehouse alone. Focus your patrols on the other side of town."
Wow.
Right. By knowingly and willfully consenting to the unlawful act and using their influence to shield the syndicate from arrest or prosecution, that mayor is a protector. And under this law, they face severe, life-altering penalties. The law targets the invisible shield just as aggressively as the sword.
That makes total sense. You have to dismantle the corruption that allows the trade to breathe in the first place. Now let's talk about the actual sale of Drug Section 5.
The sale, trading, administration, dispensation, delivery, distribution, and transportation.
Exactly. Again, the baseline penalty is life imprisonment to death. But there are these specially aggravated circumstances. Basically, situations where the judge has no choice but to throw the absolute maximum penalty at you.
Yes, the law operates with a very keen spatial and demographic awareness. It cares deeply about where the crime happens and who is involved. For example, if a drug sale transpires within 100 meters from a school, that is specially aggravated.
100 meters, that's what, just a city block?
Roughly, yes.
So if you sell a gram of drugs on a street corner, and there happens to be an elementary school 1 block away, your fate is sealed.
Exactly. The state creates a highly protected blast radius around vulnerable populations. It's the same if you use minors or mentally incapacitated individuals as runners or couriers.
Which cartels do all the time.
They do. And if a syndicate hires a 14-year-old kid to deliver a package, the adults running the operation face the absolute maximum penalty. If the victim of the sale is a minor, or if the drug actually causes someone's death, the hammer falls completely. There's no leniency whatsoever.
And that spatial awareness applies to the clandestine labs too, right?
It does. If any phase of the manufacturing process happens within 100 meters of a residential area, a business, a church, or a school, it's aggravated.
Wow.
Or if the lab is secured with booby traps. Or if it's cleverly concealed within the operations of a legitimate business like, say, hiding a meth lab inside an industrial laundromat.
Breaking Bad style.
Precisely.
Yeah.
If they do that, the penalties escalate to the absolute maximum. The state punishes the deception and the public endangerment as severely as the drug making itself.
Okay, so we've talked about the cartel bosses, the corrupt mayors, the underground chemists. But what about the physical spaces where drugs are consumed?
The dens.
Right. Section 6 targets the maintenance of a den, dive, or resort. This is a place where drugs are administered, delivered, or sold. If you run one of these places, obviously you're going away for life. But what does this mean for the little guy? Let's say you just got a job working the door at a sketchy underground club. You're just checking IDs. Are you on the hook for life imprisonment if people are using drugs inside?
This is where the net gets incredibly wide and deeply frightening. Section 7 explicitly addresses the employees and visitors of a den, dive, or resort.
Okay, lay it on me.
You absolutely do not have to be the kingpin or the owner to ruin your life. Simply being an employee of that sketchy club, and the law broadly includes caretakers, helpers, watchmen, lookouts, and other persons working there, whether you are getting paid or not, is heavily penalized.
Seriously?
Yes. If you know it's a drug den and you work there, you are complicit in maintaining the infrastructure of the drug trade.
Wait, it gets crazier. The law even penalizes being a visitor?
It does.
Like if you are just a guest, a patron, if you visit a den, dive, or resort and you know that dangerous drugs are being used there, you are criminally liable just for walking through the door and staying.
It's true. However, the law does require proof of knowledge. The Supreme Court established long ago in foundational principles regarding illegal spaces like opium dens back in the day, that mere presence in a room where someone happens to be smoking opium isn't strictly unlawful unless the place is actually established as an opium den and you knew the nature of the location.
Okay, so you have to know what you're walking into.
Exactly. You have to know you are entering a space dedicated to illicit activity. If you go to a friend's house for dinner and someone secretly sneaks into the bathroom to use drugs, you aren't automatically guilty of visiting a den. The state must prove the nature of the space and your awareness of it.
That is a massive distinction, but still terrifying. And what happens to the property itself? Let's say I rent out my apartment to a tenant and they turn it into a drug den without me knowing.
If the state can prove you did know, the consequences are severe. The property can be confiscated and escheat to the government.
Escheat. Define that for us.
Right. So escheat is a legal doctrine where property reverts to the state. Basically, the government permanently seizes your property, absorbs it, and you lose all ownership rights, usually without compensation.
That's rough.
But the law demands due process. The criminal complaint must specifically allege that the place was intentionally used to further the crime. The prosecution must prove that intent on the part of the owner, and the owner must actually be included as an accused in the trial.
Okay, good.
Yeah, they can't just steal your house because your tenant was a criminal. They have to prove you were complicit in allowing the den to exist.
Well, it's one thing to talk about taking down massive cartel operations, confiscating apartment buildings, and prosecuting corrupt mayors, but let's be honest.
Yeah.
The reality on the ground, the day-to-day grind of the drug war, almost always comes down to what a police officer finds in a single person's pockets during a stop.
Almost entirely, yes.
And legally, defining what it means to possess something is surprisingly complicated and wildly punitive.
It is the most common battleground in drug enforcement. Section 11 of RANL 165 deals entirely with the possession of dangerous drugs. And unlike importation, where quantity doesn't matter, possession is strictly mathematically tiered by weight.
Right.
The penalties escalate dramatically based on the exact number of grams involved.
Let's run through this calculus, because these weights are the absolute terrifying baseline of this law. The maximum penalty, again, life imprisonment to death, kicks in at relatively microscopic amounts for certain drugs. It's 10 grams or more of opium, morphine, heroin, or cocaine.
To visualize that for you, 10 grams is roughly the weight of 2 standard packets of sugar you'd find at a coffee shop.
2 sugar packets of heroin and your life is over. For shabu methamphetamine, the maximum penalty kicks in at 50 grams or more, but for marijuana, it's 500 grams or more. Why the massive discrepancy? Why 50 grams for shabu, but 500 for marijuana?
Well, it comes down to the legislative assessment of potency, societal harm, and the nature of the drug. Marijuana is plant-based, often less refined, and historically viewed by this legal framework as requiring larger bulk quantities to equal the societal damage of highly refined synthetic stimulants like shabu or heroin.
I see.
The state considers 50 grams of shabu to be a far more dangerous trafficable quantity than 50 grams of dried marijuana leaves.
But let's be clear, even if you have amounts below those thresholds, the penalties are still completely crushing.
Oh, absolutely.
If you possess 10 grams to less than 50 grams of shabu, you are still looking at life imprisonment and a massive fine. Even if you possess less than 5 grams, literally a pinch of powder, the penalty is 12 years and 1 day to 20 years in prison.
Yeah.
A decade of your life gone for a fraction of an ounce.
And because the penalties are so severe, the legal definition of possession has been heavily litigated. What does it actually mean to possess something?
Right.
The Supreme Court has established foundational principles here. To be convicted of possession, the state must demonstrate occupancy, or a taking, and crucially, an intent to possess. This is the legal doctrine of animus possidendi.
Animus possidendi, intent to possess. Okay, let's use a scenario. Let's say I'm standing at a bus stop. A guy next to me says, "Hey, can you hold this closed soda can for a second while I tie my shoe?" I take the can. Suddenly, the police swarm us. They open the can, and it's stuffed full of opium. Am I guilty of possession? I mean, I was physically holding it.
Under the fundamental principles established by the Supreme Court, Mere possession without intent is not punishable. If there's absolutely no proof that you knew the soda contained opium, you lack animus possidendi.
Phew.
You did not have the intent to possess a dangerous drug. You had the intent to hold a soda can. Therefore, you should not be convicted.
Should not. But the reality is much scarier, isn't it? Because the burden of proof can shift.
It can shift rapidly. The courts have ruled that if dangerous drugs are found inside your house or within premises you control, that discovery raises a prima facie evidence of knowledge, or animus possidendi.
Prima facie meaning at first sight, like it looks like you're guilty.
Precisely. The law presumes that if it's in your house, you know it's there. The burden then shifts to you, the accused, to rebut that presumption. You have to prove a negative.
Which is impossible.
It's incredibly difficult to do in a courtroom, yes.
Right.
You have to establish the actual absence of knowledge.
And it gets even more complicated with something called constructive possession. Let's do another scenario.
All right.
Let's say I rent a car. I'm driving 3 of my friends to a party. We get pulled over. The police search the car and find a bag of shabu stuffed under the passenger seat. I wasn't touching it. It wasn't in my pocket. Am I going to prison for life? It sounds like a game of legal hot potato where nobody wants to admit holding the bag.
That's a very common real-world scenario. Constructive possession means that to possess isn't strictly limited to manual touch or personal physical custody. You don't have to be holding it in your fist.
Right.
If you exercise control, management, and disposition over the drugs, or over the space where the drugs are hidden, you are in constructive possession. In your scenario, it's your rental car. You are the driver. You control the space. Yeah, the state could argue that you had control over the vehicle and therefore constructive possession of its contents. It would be up to you to prove that one of your friends hid it there without your knowledge.
That is terrifying. It means your physical proximity and your ownership of a space can be weaponized against you. And the state's net gets even tighter when we look at Section 12, which covers the possession of equipment, instruments, apparatus, and paraphernalia.
Yes.
We're talking about glass pipes, tutors, syringes.
Possessing the paraphernalia is a separate, distinct crime from possessing the drug itself.
But there's a fascinating, almost devious trapdoor built into this section. Under the second paragraph of Section 12, the possession of this equipment is prima facie evidence that the possessor has actually smoked, consumed, or used a dangerous drug.
It creates a cascading legal effect. Just holding the glass pipe triggers a legal presumption that you have violated Section 15, which penalizes the actual use of the drug.
So the tool presumes the act.
Exactly. You are now fighting 2 presumptions of guilt instead of 1.
Furthermore, the law introduces special aggravating circumstances just for possession. Let's say you possess drugs, or even just the paraphernalia during a party, a social gathering, or simply in the proximate company of at least 2 other people.
Yes, Sections 13 and 14.
Under those sections, the maximum penalties provided in the law are automatically applied, regardless of the purity or quantity of the drug. If you have a single gram of weed at a party with 3 friends, the state treats it with maximum severity.
The legislative intent is clear there. They want to severely punish the social facilitation of drug use. They view drug use in a group as inherently more dangerous to society than isolated use, perhaps because it encourages others or normalizes the behavior.
So because possession is so heavily punished, and because a few grams can mean decades in prison, the actual method of how police find or catch you in possession becomes the absolute most contentious battleground in criminal law.
Oh, absolutely.
The entire trial often hinges on the very moment of arrest. And this leads us to the terrifying cat and mouse game of the buy-bust operation versus the frame-up.
In the common parlance of the drug trade, buying is referred to as making a score. To counter this hidden economy, law enforcement utilizes the buy-bust operation. Legally, this is defined as a form of entrapment used to apprehend a pusher or peddler in flagrante delicto.
In flagrante delicto, caught red-handed, caught in the act of committing the offense. Walk me through exactly how a buy-bust works in the real world.
A buy-bust is a sting operation. Usually the police have an informant who introduces an undercover police officer, they call him the poser buyer, to a suspected drug seller.
Okay.
They arrange a meeting. The poser buyer shows up with marked money, often domed with ultraviolet powder. The seller hands over the drugs, the poser buyer hands over the cash.
And then boom.
Exactly. The moment that exchange happens, the crime is complete. The undercover officer signals the backup team, and they swarm in and arrest the seller immediately.
And the rules surrounding a buy-bust give incredible, almost unchecked leeway to the police. I was reading through the foundational jurisprudence on this. A formal complaint from a citizen is not required before the police can set up an entrapment.
That's right.
Furthermore, the Supreme Court has ruled that the police do not need a specific mission order, they do not need to conduct prior surveillance on the target, and there is no strictly established standard operating procedure they absolutely must follow to make the sting valid.
The law allows for extreme agility. A police officer can essentially pose as a buyer, hand over marked money, receive the drug, and instantly arrest the seller without a warrant. The justification is that the crime is happening right in front of them.
But stop and think about the terrifying power dynamic that creates. A police officer can arrest a citizen without a warrant, without prior surveillance, based entirely on their own testimony that a secret transaction just occurred in an alleyway.
It is an immense power. And what's fascinating is that the Supreme Court itself recognizes the inherent structural dangers of this power.
They do.
Yes. In multiple landmark decisions, the court has explicitly noted that the practice of entrapping drug traffickers through a poser buyer is highly susceptible to mistake, to harassment, to extortion, and to outright abuse by corrupt officers.
Extortion, let's talk about that. Because of this dynamic, the defense of being framed is the absolute standard defense in drug cases.
Yes, the frame-up.
The scenario goes like this. Corrupt cops grab an innocent person off the street, they throw a bag of shabu on the table and say, give us 100,000 pesos, or we write a report saying, we caught you selling this to us in a buy bust, you'll go to prison for life.
It's a nightmare scenario.
The defense of frame-up is easily fabricated by actual criminals, yes, but it is also a very real, documented nightmare for innocent people.
The courts are well aware of this dark reality. However, they operate with a legal doctrine called the presumption of regularity in the performance of official duties. This means the court starts by assuming the police did their jobs correctly and honestly.
Which puts the defendant at a massive disadvantage. It's your word against the police.
True, but the Supreme Court has also firmly established that this presumption of regularity cannot prevail over the constitutional presumption of innocence. The police cannot simply say, trust us. The prosecution still bears the heavy, unyielding burden of proving guilt beyond a reasonable doubt.
Well, to counter this very real threat of corrupt officials extorting and framing innocent people, the 2002 law did something drastic. It severely strengthened the penalties for planting evidence.
Yes, it did.
Under the old 1972 law, the crime of planting evidence specifically targeted government officials or police who framed someone. But under RA 9165, Section 29 expands this dramatically.
It does. The crime of planting of evidence can now be committed by any person, not just the police. It is defined as the willful act of maliciously and surreptitiously inserting, placing, adding, or attaching directly or indirectly, overtly or covertly, whatever quantity of any dangerous drug or precursor into the person, house, effects, or immediate vicinity of an innocent individual for the purpose of incriminating them.
And the penalty for planting evidence? Death. The law literally prescribes the ultimate maximum penalty for weaponizing the drug law against an innocent person.
It reflects the legislature's understanding that falsely accusing someone of a drug crime under this specific law is akin to murdering them, because the penalties for possession and sale are life-ending.
But this creates a massive logistical problem. If police don't need warrants for a buy bust, and the penalty for planting evidence is death because corruption is so prevalent, how does a judge actually know the truth?
That's the million-dollar question.
How does the court know that the baggie of white powder sitting on the evidence table during the trial is the exact same baggie of white powder taken from the suspect on the street 6 months ago? How do they know the police didn't swap it out, or pinch some off to sell, or manufacture the whole thing? Enter the most critical, highly litigated procedural rule in the entire law, Section 21.
Section 21 is the sacred chain of custody. It is the beating heart of a drug prosecution. It dictates exactly, step by step, how confiscated, seized, or surrendered dangerous drugs and paraphernalia must be handled, documented, and disposed of.
Why is this so crucial?
Because of the concept of corpus delicti, the body of the crime. In a murder case, the body is the corpus delicti. In a drug case, the drug itself is the corpus delicti.
Oh, okay.
The Supreme Court has stated unequivocally that the existence of the dangerous drug is a condition sine qua non for conviction. Without the drug, there is no crime.
So if the state cannot definitively prove the chain of custody, if they cannot trace an unbroken line showing that the white powder tested by the forensic chemist is the exact same white powder seized from the suspect's pocket during the buy bust, the entire theory of the case collapses.
Entirely.
The evidence becomes legally invisible and the suspect walks free.
Exactly. To prevent this, to ensure the integrity of the evidence against the constant threat of police corruption or incompetence. Section 21 mandates a highly specific, almost theatrical level of witnessing. Immediately upon acquiring initial custody and control of the drugs, the apprehending team must conduct a physical inventory and photograph the items.
And they can't just do it alone in a back room at the police station. This is where the theater comes in. The law states they have to do it in the presence of the accused or their legal counsel.
Right.
But that's not all. They must also summon a representative from the media, a representative from the Department of Justice, and indeed an elected public official. All of these people have to stand there, watch the police weigh and inventory the drugs, and then sign the inventory sheet.
Just imagine the logistics of that for a second. It's 3:00 a.m. The police have just concluded a dangerous, adrenaline-fueled buy-bust in a dark alley. Now, before they can move the evidence, they have to wake up a local city councilor, call a reporter from a local newspaper, and get a DOJ lawyer out of bed and have them all congregate in this alleyway to watch them take a photograph of a plastic bag.
It's like handling a cursed artifact. The moment the police touch the drug, a metaphorical timer starts ticking. You have to document exactly who touched it, when they touched it, and you have to have independent third-party civilians watching every single second.
Yes.
Because if that chain of custody is broken, if the curse escapes, the magic of the evidence vanishes in court.
The logistical nightmare of this was so severe that the law was later amended by RA 11640 to add a tiny bit of practicality. It stated that the inventory and photography shall be conducted at the place where the search warrant is served, or, in warrantless seizures like a buy-bust, it can be done at the nearest police station or the nearest office of the apprehending team.
Okay, that helps a little.
It also added a vital saving clause. Non-compliance with these strict requirements under justifiable grounds won't automatically render the seizure void, as long as the prosecution can prove the integrity and evidentiary value of the seized items were properly preserved.
But the core principle remains: document everything or lose the case. And the law doesn't want these massive quantities of seized drugs just sitting in police evidence lockers for years, right? That's a recipe for corruption, for police recycling the drugs back onto the street.
Which is why Section 21 lays out an incredibly rapid timeline for destruction. Within 72 hours of the criminal case being filed, the court must conduct an ocular inspection of the seized drugs.
So the judge actually looks at the pile of drugs.
Yes. And within 24 hours after that ocular inspection, the Philippine Drug Enforcement Agency, the PDEA, must proceed with the destruction or burning of the items. They literally incinerate the bulk of the evidence almost immediately.
Wow. And again, this destruction must be witnessed by the accused, the media, the DOJ, civil society groups, and elected officials. They turn the destruction of the drug into a highly public event to prove it was actually destroyed. But they don't burn all of it, right? How do they have evidence for the trial that might happen a year later?
They retain a representative sample, just a small fraction, which is duly weighed, recorded, and kept in a highly secure vault for the trial. Once the trial finally concludes, the prosecutor requests leave from the court to turn that final, tiny sample over to PDEA for destruction within another 24 hours.
So the state's goal is to vaporize the substance as quickly as legally possible.
Yes, to get it out of the system.
So we see the strictness of Section 21 as the legislature attempting to limit police abuse and ensure the absolute integrity of evidence. But this creates a fascinating high-stakes tension. What happens when the legislature itself, in its zeal to create this unrelenting, unyielding campaign against drugs, steps over the line and violates the Constitution?
This is where the architecture of a democracy is truly tested. It brings us to the monumental constitutional clashes where the judiciary had to aggressively push back against the legislature. There are two massive, landscape-altering Supreme Court decisions we really must discuss.
Let's start with the battle over plea bargaining. The case is Estepona versus Labrigo from 2017. Here is the setup. Section 23 of RA 9165 had a very stark, absolute rule. It said any person charged under the Drug Act, regardless of the imposable penalty, was absolutely disqualified from availing of plea bargaining.
Right. Now, plea bargaining is when an accused agrees to plead guilty to a lesser offense in exchange for a lighter sentence. It saves the court time and resources. But Congress, wanting to appear tough on crime, banned it entirely for drug cases.
Yeah.
If you were caught with 0.1 grams of shabu, you had to go to a full trial facing years in prison. You could not plead out.
But in Estepona, the Supreme Court struck down Section 23. They declared the statutory prohibition against plea bargaining in drug cases unconstitutional. Why? Was it because it was too cruel?
No, the reasoning was purely structural. It was a defense of the separation of powers. The Constitution divides the government into three co-equal branches. The legislature writes the laws, the executive enforces them, and the judiciary interprets the laws and exclusively manages the operations of the courts.
Right.
The Supreme Court ruled that plea bargaining is not a substantive law. It doesn't define what a crime is. Rather, plea bargaining is a rule of procedure. It dictates how a trial moves through the courtroom.
Okay, I see where this is going.
And under the Philippine Constitution, the power to promulgate rules of procedure belongs exclusively to the Supreme Court. By passing a statute that forbade plea bargaining, Congress overstepped its bounds. They walked into the judiciary's house and tried to rearrange the furniture.
I love that.
Striking down Section 23 protected the institutional independence of the courts and, as a practical byproduct, allowed for the more efficient disposition of thousands of lower-level backlogged drug cases.
It's a beautiful example of checks and balances. Congress tried to use a sledgehammer, and the Supreme Court said, you don't have the authority to swing that here.
Exactly.
The second massive clash is Social Justice Society versus Dangerous Drugs Board from 2008. This deals with Section 36 of the law, which mandated authorized drug testing for a huge, sweeping swath of the population.
Section 36 attempted to mandate random or routine drug testing for candidates for public office, for persons charged with criminal offenses, for students, and for employees in public and private offices. The Supreme Court had to take a scalpel to this section and parse out which of these mandates violated the Constitution and which were legally permissible.
Let's start with candidates for public office. Say, someone running for senator. Congress wrote the law saying if you want to run for office, you have to pass a drug test. That sounds reasonable to a layperson, but the court struck it down. Why?
Because the Philippine Constitution specifically lists the qualifications for running for senator. It lists age, citizenship, residency, and literacy. That's it. The Supreme Court ruled that by requiring a negative drug test, Congress was essentially imposing an additional qualification for office. A statute cannot amend the Constitution. If you want to require drug tests for senators, you have to rewrite the Constitution, not just pass a drug law.
Brilliant. Okay, what about persons charged with a criminal offense? The law said if you are accused of a crime with a penalty of more than 6 years, you must be drug tested.
The court struck that down as well. They ruled this was a glaring violation of the right to privacy and the fundamental guarantee against self-incrimination.
Right, because you'd be providing evidence against yourself.
Exactly. You were targeting specific individuals without their consent, forcing a bodily intrusion simply because they were accused of a crime. You cannot force someone to provide evidence that might incriminate them in a totally separate drug offense.
So, politicians are protected, and accused criminals are protected. But here's the part that is so confusing to me. The court ruled that random drug testing for high school and college students and for ordinary officers and employees of public and private offices is actually perfectly constitutional. How does that make sense? Why does an ordinary accountant or a 16-year-old high school student have fewer privacy rights than someone accused of a severe crime?
It is a crucial, nuanced distinction based on the context of the environment. The court upheld random, suspicionless testing for students and employees based on two specific legal doctrines.
Okay, what's the one for students?
For students, it relies on the doctrine of parental authority. Schools act in loco parentis, in the place of the parents. They have a heightened duty and authority to provide a safe, drug-free learning environment for minors. The expectation of privacy in a school is legally lower than on the street.
And for the accountant in an office building?
For workplaces, the state has a compelling administrative interest in maintaining drug-free environments to ensure occupational safety and economic productivity. The court found that in these specific, highly regulated administrative contexts, the state's police power, its inherent right to protect the general welfare, outweighed the individual's right to absolute privacy. These are considered reasonable administrative searches, not criminal investigations.
So the law demands strict accountability from everyday citizens in their schools and offices, and the Supreme Court demands accountability from the legislature to respect the Constitution. But what about the enforcers themselves? What about the government agents fighting this war?
Yes.
Because the law has special built-in mechanisms to demand accountability from them and to crack open secretive drug syndicates from the inside. We're moving into the final layer of this deep dive, the inside job.
We already discussed how Section 29 uses the ultimate threat, the death penalty, to punish any person, including police, who plants evidence. But the law goes further. Section 27 targets public officers or employees who misappropriate, misapply, or fail to account for the confiscated drugs, paraphernalia, or the millions of pesos in proceeds seized during raids.
If a cop stims a little off the top of a massive drug bust,
The penalty is life imprisonment to death, plus a fine of up to 10 million pesos, and absolute perpetual disqualification from holding any public office.
and it extends to the political class too. If an elected official, local or national, is found to have benefited from the proceeds of drug trafficking, or even if they knowingly receive financial contributions for their campaign from persons found guilty of drug trafficking,
They're subject to removal from office and perpetual disqualification.
the law is frantically trying to build a firewall between drug money and political power, knowing how easily one corrupts the other.
But while Section 27 uses a massive stick to beat back corruption, Section 33 offers a very specific, highly calculated carrot: immunity from prosecution and punishment. This is the state's primary, most effective tool for dismantling tight-knit drug syndicates from the inside out.
The classic informant. To get this immunity, a person who has violated certain lower-level sections of the law, like possession or use, must voluntarily come forward and give information about major violations. They have to expose the manufacturing, the importation, the cartel activities. They have to provide information that actually leads to the arrest of syndicate members, and they must willingly testify against them in open court.
It is a dangerous game, and there are strict legal requirements. The information provided must be absolutely necessary for a conviction. The state can't already have it. It must be corroborated by other evidence. And crucially, the informant cannot appear to be the most guilty person involved in the offense.
Oh, so the kingpin can't snitch.
Right? The kingpin cannot testify against his foot soldiers to get immunity. The state is essentially trading a small fish to catch a whale. And this specific immunity provision in RA 9165 is so powerful, it takes precedence over the standard rules of criminal procedure and the General Witness Protection Act.
But here is the brilliant part of the law's design. What happens if the informant lies? What if they use this immunity to frame a rival gang member? It's a completely sealed ecosystem. The law predicts human corruption, it expects cops to steal evidence, it expects informants to lie, and it builds trap doors right into the statute to punish them.
Section 34 covers the termination of immunity.
Right.
If the information provided by the informant is proven to be false, malicious, or made just to harass someone, or if the informant gets cold feet and refuses to testify in court without just cause, the trapdoor opens. The immunity is immediately stripped away. They become instantly subject to prosecution for their original drug offense, and on top of that, they can face additional criminal charges like perjury or contempt of court.
It reflects a deep, perhaps entirely necessary cynicism about the realities of the drug trade. The law recognizes that the enormous, staggering amounts of money and power involved will inevitably corrupt some of the people tasked with enforcing the law, and that informants from the underworld are inherently unreliable, self-serving actors. The law trusts no one.
It trusts only the rigid mechanisms it has created.
We have covered immense ground today. Let's trace the arc of this incredible journey. We started by looking at how a nation upgraded its legal operating system, shifting from the analog penal code reliant days of 1972 into the highly specialized, rigid behemoth of the 2002 Comprehensive Dangerous Drugs Act. We saw the state adapt to synthetic chemistry, expanding its lexicon to target not just the final drug, but the chemical precursors, the specialized glass fermenters, and even the digital chat rooms used to trade them.
We navigated the terrifying, heavy hand of state power, exploring penalties that reach life imprisonment to death simply for importing a substance, and saw how that power targets the shadowy protectors, shielding the syndicates. We learned that simply being an employee at a nightclub functioning as a drug den can end your life as a free citizen, and how property itself can escheat to the government.
We then explored the rigid mathematical calculus of possession, where mere grams, the weight of a sugar packet, dictate decades in prison. We broke down the vital legal concepts of animus possidendi, the intent to possess, and the dangerous reality of constructive possession, where a bag left under the seat of your car shifts the burden of proof onto you. We saw the trapdoors, where simply holding a glass pipe presumes you've used the drug.
We examined the perilous, adrenaline-fueled theater of the buy-bust operation, recognizing it as a highly effective but dangerously susceptible tool that requires no warrant and no prior surveillance. We weighed that against the horrifying reality of extortion in the frame-up, understanding why the state prescribes a death penalty for planting evidence.
We walked step by step through the sacred, meticulous chain of custody required by Section 21, watching politicians and reporters gather in alleys to document the corpus delicti, and saw how quickly the state rushes to incinerate the evidence. And finally, we watch the Supreme Court step onto the battlefield to ensure the Constitution isn't trampled in the zeal of the drug war, protecting the separation of powers in Estepona and the right against self-incrimination in the social justice society case.
Yes.
We saw a law that deploys immunity as a weapon and severe corruption penalties as a shield.
It is a breathtakingly complex legal ecosystem. And while this has been a deep dive specifically into Philippine law, I think you'll agree that the core themes here are profoundly universal. The perpetual tension between civil liberties and public safety, the struggle to write laws that can keep pace with human ingenuity and human corruption, and the terrifying, godlike power of the state to deprive a citizen of their liberty or their life. These are struggles playing out in courtrooms, legislatures, and dark alleyways around the entire globe.
It really makes you think about the nature of the law itself and its limits. I want to leave you with a final thought to mull over. Consider the incredibly rapid, almost exponential pace of synthetic drug development happening right now in underground labs. If a law written in 2002 had to specifically name the chemical structures of ecstasy and shabu to make them illegal and actionable in court, how does a rigid legal system ever truly keep up?
It's a great question.
Imagine an underground chemist who tweaks just one molecule of a compound in a lab tomorrow. They create a drug that has the exact same effect, but technically, molecularly, doesn't exist in the law books yet. If the state must precisely define its enemy to fight it, does the law always have to remain one desperate step behind chemistry?
That is the perpetual challenge of the modern era. As long as there is immense demand, there will be relentless, brilliant innovation on the supply side, forcing the machinery of the law to constantly adapt, expand, and perhaps become even more severe.
Thank you for joining us on this deep dive. Keep questioning the fine print of the world around you, because as we've seen today, sometimes the difference between absolute freedom and a life sentence is written in the murky, microscopic details.
Welcome to the debate. Imagine you're tasked with building a containment structure for a highly volatile substance, something like a nuclear reactor.
Okay. High stakes.
Extremely high stakes. When engineers design that kind of architecture, the governing philosophy is just absolute intolerance for breaches, right? You don't install flexible doors. You don't build porous walls.
You seal it tight.
You seal it tight. You create a rigid, unyielding framework because the threat is existential. A single leak means the entire system fails, and the fallout is catastrophic. And well, in 2002, the government of the Philippines essentially attempted to build a legal nuclear reactor to contain the drug trade.
Right, and the intention there is completely understandable. The architecture of containment has to be absolute. But the problem arises when you try to apply that kind of uncompromising, zero-tolerance engineering to human justice systems.
Because it's not a machine.
Exactly. In the realm of law, absolute rigidity usually ends up fracturing the very structural foundations it was actually built to protect.
And that specific friction is exactly what we are unpacking today. We're looking at the profound tension between rigorous legislative frameworks designed to combat severe social crises and the constitutional boundaries that exist to protect individual rights.
And institutional independence, too. Specifically, we're diving into the Philippines' Comprehensive Dangerous Drugs Act of 2002. It's widely known as Republic Act No. 9165.
Right.
We're going to examine this strict, unyielding text of this law and weigh it against subsequent landmark rulings from the Philippine Supreme Court. Rulings that, interestingly enough, actually struck down some of the law's most rigid, high-profile provisions.
So the central question before us is this. In the pursuit of an intensive and unrelenting campaign against the trafficking and use of dangerous drugs, does a strict statutory framework represent an essential exercise of state police power?
Or does that level of legislative engineering inevitably lead to unconstitutional overreach?
I will be taking the position that this law's uncompromising provisions, such as absolute prohibitions on plea bargaining and mandatory drug testing, were justified, necessary legislative mechanisms to eradicate a severe social ill.
And I'll be taking the contrasting position that no matter how compelling the state's interests might be, legislative zeal cannot simply consume the Bill of Rights or the judiciary's exclusive procedural authority.
Okay, so let's start with the baseline reality that prompted this law. The Fundamental Policy Declaration of the 2002 Act explicitly identifies dangerous drugs as, quote, one of today's more serious social ills.
It's a massive crisis.
It is. We aren't talking about a minor administrative headache here. We're talking about organized, well-funded drug syndicates. And syndicates are essentially corporate entities that exploit every conceivable loophole in the justice system.
Sure, they have lawyers, resources.
Exactly. That is why the legislature designed this law to be a closed-loop system of accountability. They imposed maximum penalties, like life imprisonment or reclusion perpetua, all the way to death for importation or manufacturing.
Heavy penalties.
Extremely heavy. But critically, they entirely removed procedural flexibilities. They didn't want anyone, negotiating their way out of a severe sentence.
And that is exactly where the constitutional alarm bells start ringing for me. I mean, I understand the logic of wanting a closed-loop system, but legislative intent, no matter how urgently needed, has to exist within the framework of checks and balances.
Even during an existential crisis?
Even then, especially then. When you actually read the landmark Supreme Court decisions surrounding this law, you witness the highest court in the land systematically dismantling those absolute bans. The court proved that police power, which is the state's inherent right to protect its citizens, it must always yield to the separation of powers.
Well, let's test that idea by looking closely at the mechanics of plea bargaining, because this was one of the most controversial elements of the law.
Under Section 23, right?
Right, Section 23. Under the old framework, the 1972 law, plea bargaining was only prohibited if you committed a crime that carried the absolute maximum penalty, which makes sense. If you're facing the death penalty for running a massive drug cartel, you shouldn't be able to just plead guilty to a lesser charge and walk away in a few years.
Agreed.
But when the 2002 law was drafted, Congress expanded that net. They explicitly disqualified anyone charged under the act from availing of a plea bargain, regardless of the imposable penalty.
Right, a total and absolute ban. Whether you were a cartel boss or, a teenager caught with a gram of marijuana.
Yes, a total ban. And think about the mechanics of why they did that. If you leave even one procedural leak in the system, like allowing a low-level street pusher to cop a plea deal for mere possession rather than drug selling, you compromise the entire integrity of the enforcement.
But you're assuming.
The syndicates adapt. They use fall guys. They hire kids to carry the drugs, knowing that if the kid gets caught, they can just plea bargain down to a slap on the wrist, and the cycle continues unbroken.
It's a valid operational concern.
Right. The legislature recognized that flexibility was the enemy of enforcement here. By banning plea bargains, they forced every single case to go to trial, ensuring maximum pressure on the syndicates.
Okay, that sounds like an airtight strategy on a whiteboard, but let's look at the actual constitutional mechanics of what Congress did there. In 2017, the Supreme Court ruled on this exact provision in Estepona v. Labrigo.
And they struck it down.
Down because it was too harsh, or because they felt bad for the low-level offenders. They struck it down because it was a profound violation of the separation of powers.
How so? I mean, the legislature defines what a crime is, right? And they define what the penalty is.
Yes, they do.
So if they have the power to dictate that selling drugs gets you life in prison, why don't they have the power to dictate that the penalty cannot be negotiated?
It comes down to the difference between substantive law and procedural law. Think of the justice system as a massive multi-signature vault. Congress has the authority to decide what goes into the vault. They define the crime. And they decide how heavy the door is, they set the penalty.
Okay, that's substantive law.
Exactly. But plea bargaining is not a substantive right. It is a rule of procedure. It dictates how a trial actually runs. And under the Philippine Constitution, the power to spin the tumblers, the power to promulgate rules concerning pleading, practice, and procedure in all courts belongs exclusively to the Supreme Court. Congress essentially tried to take the judiciary's key.
I see the distinction. I do. But couldn't you argue that a plea bargain directly alters the penalty? If a prosecutor and a judge agreed to let someone plead to a lesser offense, they're effectively sidestepping the severe penalty that Congress deliberately constructed.
No, they are managing the docket, the process of how a case moves through the court, how a judge allocates time, how they evaluate the weight of the evidence before a full trial. That is inherently judicial.
But it overrides the legislative intent.
The Supreme Court in Estepona made crystal clear that Congress overstepped its bounds. By forbidding plea bargaining, the legislature was essentially standing inside the courtroom, telling the judge how to run their own proceedings. The institutional independence of the courts to ensure a speedy and inexpensive disposition of cases, it has to survive even the strictest anti-drug campaigns. Because if you allow the legislature to dictate courtroom procedure here, you've set a precedent where they can do it anywhere.
Okay, that is a fair structural argument. But if Congress couldn't dictate the procedure inside the courtroom, they certainly tried to control who was running the system and who was entering it through another massive dragnet.
Mandatory drug testing.
Mandatory drug testing. This was another cornerstone of the 2002 law, under Section 36. And again, the underlying logic is intensely practical. The law mandated drug testing for all candidates for public office. It also mandated testing for anyone charged with a criminal offense that carried a penalty of more than 6 years in prison.
And once again, we see a collision between intensely practical logic and constitutional validity. They aren't the same thing.
But walk through the logic with me for a second. If you're a candidate asking the public to elect you to write the laws, or if you're an individual navigating the severe end of the felony docket, ensuring a drug-free status seems like a baseline prerequisite.
A prerequisite for what exactly?
For integrity, the state recognized that narco-politics is a real threat. You absolutely cannot win a war on drugs if the politicians funding the police or the people moving through the criminal courts are compromised by the very substance you're trying to eradicate. It's an administrative safeguard.
It might feel entirely reasonable as an administrative safeguard, but the Supreme Court dismantled that exact logic in the 2008 Social Justice Society ruling. Let's break it into two parts, starting with the candidates for public office.
Okay.
The Supreme Court struck that testing requirement down because the qualifications to run for national offices like senator or president are explicitly, exhaustively laid out in the Constitution itself. You must be a certain age, you must be a citizen, you must be able to read and write.
Right. Those are the baseline constitutional requirements, but isn't holding public office a privilege? We ask candidates to submit all sorts of administrative paperwork, like statements of assets and liabilities. Why is a drug test crossing the line?
Because submitting financial paperwork is about transparency, whereas a drug test is an active barrier to entry. By requiring a negative drug test to even run for office, Congress was functionally adding a brand new qualification that the framers of the Constitution didn't authorize.
So it's a structural barrier.
Yes. If the legislature wants to add a qualification for a national constitutional office, they cannot just pass a regular statute. They have to formally amend the Constitution. It's a brilliant example of the court saying, we agree with your goal, but you cannot use illegal tools to achieve it.
Okay, I can concede the procedural point on candidates in constitutional amendments. That makes sense. But the court went further in that same ruling. They also struck down the mandatory drug testing for accused persons, people who are already charged with serious crimes.
Yes, and the reasoning there is even more deeply rooted in fundamental human rights. The court found that forcing a person who has been charged with a crime to undergo a drug test without their consent is a blatant violation of their right to privacy and the guarantee against self-incrimination.
Now, this is where I have to push back on the court's consistency. Because if you read the nuances of that exact same ruling, the Supreme Court didn't strike down all mandatory testing.
No, they didn't.
They also upheld it for employees in public and private offices. So the court clearly recognizes that the state does have the police power to conduct mandatory biological searches.
In specific contexts.
But why is a high school student or an office worker subject to a mandatory drug test, but someone accused of a violent felony gets a constitutional shield of privacy? That feels backwards.
It's not backwards at all, because the relationship between the individual and the state in those scenarios is completely different. It's actually a masterclass in judicial line drawing. Let's look at the students first. Why can the state test them?
To keep schools safe?
Yes. But legally, the court applied the concept of in loco parentis, meaning the school is acting in the place of the parents. The primary motive there is protective and rehabilitative, not punitive.
And the employees?
With employees, you're looking at a contractual environment. The state has a highly compelling interest in maintaining a safe, drug-free workplace. Furthermore, the testing is random and suspicionless. But an accused person facing a felony charge?
They're already in the system.
Exactly. They are in a fundamentally adversarial relationship with the state. The state is actively utilizing its massive resources to imprison them. to force that person to submit bodily fluid, which the state could then use to launch a brand new, separate criminal charge against them for drug use. That is the textbook definition of self-incrimination.
So it's about the coercive power.
You're using the coercive power of the state to force someone to literally generate biological evidence against themselves. The judiciary isn't blind to the drug menace. It simply demands that these administrative searches remain reasonable and constitutional.
You know, you keep bringing up the potential for the state to abuse its coercive power and the need for the judiciary to sort of step in and save the citizens from the legislature. But if we look closely at the text of the 2002 law, the legislature did foresee the potential for abuse by law enforcement.
They did?
Yes. They didn't just hand the police a blank check. They built agonizingly strict procedural safeguards directly into the statute itself.
Ah, you're referring to the chain of custody rules.
Yes, specifically Section 21 of the law, which dictates exactly how confiscated drugs must be handled. It's not a gentle guideline. It is a rigid statutory mandate. Let's walk through how a buy-bust operation actually works under this law.
Okay.
Let's say the police conduct a nighttime sting operation and arrest a suspect on the street. They seize a packet of drugs. Under normal circumstances, they might just put it in an evidence bag and drive back to the precinct. But under the 2002 law, they have to freeze. The moment the apprehending team acquires initial custody of the drugs, they must conduct a physical inventory and photograph the items right there.
Right then and there. And they can't do it alone.
Exactly. They have to wait for specific witnesses to physically arrive on the scene. It must be done in the presence of the accused, a representative from the media, a prosecutor from the Department of Justice, and an elected public official.
It's quite a crowd.
It is. All of them must sign the inventory. And to ensure the police don't just, hold on to the drugs to use later, the court must conduct an ocular inspection within 24 hours of filing. And then the National Anti-Drug Agency must destroy the bulk of the evidence within 24 hours after that.
It is incredibly detailed. I'll give you that.
And to top it off, look at Section 29. The legislature made the penalty for planting evidence for any person, including police officers, death.
Wow.
Yes. So my point is, the legislature built a massive internal mechanism to protect the presumption of innocence. They recognized that dropping the packet of meth into someone's pocket is too easy, so they demanded media and political witnesses. Given that these extreme internal safeguards exist, doesn't it make the Supreme Court's aggressive intervention on things like plea bargaining seem somewhat unnecessary? The law already polices itself.
Actually, I think it proves the exact opposite.
Really?
Yes. The extreme rigor of that inventory rule and the fact that the legislature felt compelled to threaten corrupt police officers with the death penalty proves precisely why we need independent judicial oversight. It highlights the reality on the ground.
Which is what?
Extortion. The jurisprudence explicitly acknowledges this. If you look at rulings like People v. Rigadon, the justices themselves acknowledge that planting evidence and police extortion, which is often referred to locally as hulidab, are notoriously real practices. The phrase buy-bust operation is highly susceptible to mistake, harassment, and abuse.
But again, that is exactly why the law requires a journalist and an elected official to stand there and watch the police bag the evidence.
Yes, but think about the mechanics of the real world. What happens when it's 3 a.m. and a torrential downpour and the local elected official just doesn't pick up their phone?
Well, operations still have to happen.
Right. What happens when the local journalist is busy? The police make the arrest, but they can't perfectly comply with the strict witness requirements. Now the law actually has a saving clause for this. It says that non-compliance with these strict requirements under justifiable grounds doesn't automatically throw the case out, so long as the integrity of the evidence is preserved.
Right, which is a necessary practical exception.
But the moment you introduce phrases like justifiable grounds and integrity of the evidence, you introduce human judgment. You are asking a judge to weigh whether the police acted properly despite breaking the strict rules.
Sure.
And whenever human judgment enters a process that carries a penalty of life imprisonment, two legal philosophies collide. The state enjoys a presumption of regularity in performing its duties, meaning we assume that police did their jobs correctly.
As we should.
But the accused enjoys a constitutional presumption of innocence, And the Supreme Court in Revised firmly affirmed that the presumption of regularity can never prevail over the constitutional presumption of innocence.
But if the chain of custody is slightly broken and a judge has to make a call, the severe penalties still serve as a deterrent against police framing an innocent person.
A deterrent only works if the procedural avenues to prove the abuse actually exist inside the courtroom. And that brings us perfectly back to why the Supreme Court had to strike down the ban on plea bargaining.
Oh, I see where you're going.
When Congress mandates absolute rigidity, they essentially blindfold the judges. Imagine a scenario where a low-level career is caught. The elected official didn't show up to sign the inventory, so the evidence is legally murky. Under an absolute plea bargain, the judge's hands are tied. They either have to convict the kid to life in prison on shaky evidence or let him go entirely.
And you're saying a plea bargain solves that dilemma?
It gives the judge a tool. It allows the prosecutor to say, look, the evidence is murky, but if you cooperate and give us the cartel's financier, we will let you plead to a lesser charge. The strict 2002 law completely stripped that tool away. It's mandated that things be done exactly according to the legislative design, ignoring the messy reality of street-level enforcement.
Well, that makes intuitive sense for gathering intelligence. But I would counter that the legislature didn't ignore that reality, they just formalized it.
How so?
The law provides for cooperation through Section 33. It offers immunity from prosecution for those who voluntarily give information leading to the arrest of syndicate members. They just have to qualify officially as state witnesses.
But that's a very rigid track.
Yes, because the legislature preferred a formalized, on-the-record immunity track over the backdoor, opaque negotiations of a plea bargain. They wanted the criteria clear. The informant cannot appear to be the most guilty, for instance. The statutory framework is complete.
It was a massive, sprawling framework, yes? It criminalized not just possession and sale, but acting as a coddler, maintaining a drug den, chemical diversion, even possessing the equipment meant for manufacturing. It was an unprecedented expansion of penal power.
To match an unprecedented threat.
True. But when the state casts a net that incredibly wide, the constitutional mesh holding it together has to be incredibly strong to ensure innocent citizens aren't swept up alongside the cartels. The Supreme Court's interventions, striking down the plea bargain ban, stopping the unconstitutional drug tests, those were not about weakening the fight against drugs. They were about ensuring the fight remained a lawful exercise of state power, rather than an authoritarian sweep.
You know, this has been a deeply clarifying exploration of the mechanics of this law. To summarize my stance on the debate, the uncompromising textual framework of the 2002 Dangerous Drugs Act, with its severe penalties, its incredibly strict chain of custody mandates, and its attempt to remove procedural loopholes, reflects a necessary, systematic legislative response. The state was facing an existential social threat, and the legislature built a closed-loop system because piecemeal, flexible approaches to organized drug syndicates simply fail.
And to summarize my perspective, the Supreme Court rulings that ultimately dismantled key parts of this act prove that a relentless campaign against drugs must still operate strictly within our constitutional rights. The state's police power is formidable, and it absolutely should be, but it cannot consume the institutional separation of powers, nor can it bypass the Bill of Rights just to make enforcement easier.
I think where we fundamentally converge in this debate is acknowledging the severe, undeniable reality of the drug issue itself. We also clearly agree on the absolute necessity of having strict safeguards, like those rigorous evidence inventory requirements, to balance out the heavy, coercive hand of the state during street-level operations.
I agree entirely. The friction, the core disagreement that remains, is whether the legislature has the ultimate authority to suspend standard judicial procedures in individual privacy rights in the name of solving a crisis, or if the courts must always serve as the final unyielding gatekeeper of those constitutional boundaries.
It is a profound reflection on how legal frameworks must adapt to social realities. When you build a fortress against a flood, you have to make sure you aren't sealing the inhabitants inside without air. The tension between the legislative branch's mandate to protect society and the judicial branch's mandate to protect the Constitution is ultimately what keeps the republic breathing.
Perfectly said. That balance is never static. It requires constant, vigilant recalibration by both branches of government to ensure justice is actually being served.
We encourage our listeners to look deeper into the actual case law we discussed today, to explore how these incredibly high-stakes legal philosophies play out in real courtrooms, affecting real lives. We leave you with this final thought. If a law perfectly eliminates a crisis, but permanently compromises the foundational rights of the citizens it was written to protect, has the system truly been saved, or has it simply surrendered to a different kind of threat?